come to order. Welcome to the August 10th, 2020 meeting of the City of Raleigh Board of Adjustment. My name is Rodney Swink and I'm chair of the board. I'm joined by my fellow board members, John Kuntz, our vice chair, Donald Mile, secretary, Kathy Rudisell, Justin Sutton, Stephen Kinney, and Marvin Butler. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. I would ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We conduct evidentiary hearings on requests for variances, design adjustments, design alternates, and special use permits, among other requests. Before we begin the evidentiary hearings on today's agenda, I would like to provide some important information about the steps taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with the newly enacted statutes in Session Law 2020-3, which allow for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant on today's agenda was notified before being placed on the agenda that this meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has consented to the board conducting the evidentiary hearing on their request using this remote platform. We will also confirm today at the start of each evidentiary hearing that the participants in the evidentiary hearing consent to the matter proceeding in this remote platform. If there is any objection to this matter proceeding in this remote platform, the case will not be continued. The case will be continued. Third, notice of this meeting was provided to the applicants and the public in numerous ways, well beyond the legal requirements for noticing this meeting for evidentiary hearings. Specifically, notice of today's evidentiary hearings was provided by mail to all property owners within 100 feet of each subject property. The mailed notices were sent in advance of the date set by law to provide such notice, and each notice letter notified the recipient of the remote meeting platform. The letters also stated to contact the city immediately if there were any objections to this evidentiary hearing for which the notice was sent, or to the remote meeting platform. Let me emphasize, no case is proceeding today in which the city has been contacted by an individual with an objection to the case or to the matter being heard in this remote meeting platform. Notice was also provided by posting notice on the site of each property, publishing notice in the newspaper, and providing notice on the city's website. Each notice method was also done in advance of the legal requirement to provide such notice. The notices for today's meeting contain information about the means by which the public can access the remote meeting as the meeting occurs. Fourth, any individual wishing to participate in today's evidentiary hearings was required to sign up prior to the meeting to participate. Information about this sign-up requirement, along with information about how to sign up to participate, was included in the mailed notice letters sent to each property owner within 100 feet of each subject property. This information was also included on the board's website, and among other information, a link to the board's website was included in all methods of notice. Again, no case is proceeding today in which anyone contacted the city to voice an objection to a request or the remote meeting platform. All individuals participating in today's evidentiary hearings were also required to submit a copy of any presentation, document, exhibit, or other material that they wish to submit at the evidentiary hearing prior to today's meeting. All materials that the city received from the participants in today's cases, as well as a copy of the city staff's presentations and documents, were posted online in board docs prior to this meeting. All materials that will be discussed today can be viewed at any time during today's meeting by visiting www.raleighNC.gov/board-adjustment and clicking the link to view the agenda. Finally, all individuals who signed up to participate in an evidentiary hearing on today's agenda, as well as all city staff participants, were emailed a witness oath form prior to today's meeting. Any individual planning to testify or submit evidence in an evidentiary hearing was notified that they must sign the oath form prior to today's meeting. We will also reaffirm everyone's oath on the record at today's meeting. Before we begin the evidentiary hearing on today's agenda, I would ask our attorney to briefly explain for the participants how we will be conducting today's evidentiary hearings.
Thank you, Mr. Swink. I think most of you are probably used to this process by now, but I'll go through it for you all. My name is Catherine Hoffman-Hill. I'm the attorney for the Raleigh Board of Adjustment. Today's meeting will proceed very similar to a regular meeting with a few minor adjustments. First, if at any time a participant has issues with their technology, please send a message to the moderator. Laz Perez is moderating this meeting. The chat function has been disabled for all participants and board members, except for the ability to chat to the moderator if you are having technical difficulties. We will start each evidentiary hearing by reading the list of participants signed up for that case. I will then call you each individually and ask you to state your name, address, and confirm for the record your consent to proceed in the remote meeting platform. The board chair will then ask you to reaffirm your oath on the record. Staff will then provide their presentation, and then the board members will be given an opportunity to ask staff any questions. The applicant will be then acknowledged to present their case. The board will acknowledge the attorney or applicant first as the point person for that case. I ask that when you call your witnesses, please introduce them and state their name at the beginning so that the board can know who they are. I'll remind you, we can't see you, so we are listening to you. So please make sure to state your name before speaking. Applicants and attorneys have provided their potential documents and exhibits ahead of the meeting. As a reminder, please make sure to submit your evidence on the record when you present your case. At the end of the applicant's presentation, we'll ask if city staff would like to add anything additional or ask any questions. The board will also hear from other participants who would like to speak in support or opposition of the request. When all testimony is complete, we will close the evidentiary hearing and the board members will deliberate on the item. Following deliberation, the board's chair will ask for a motion and the board will vote using a roll call method with the assistant city clerk taking the vote. So with that, I will turn it back over to Mr. Swink to conduct the evidentiary hearings.
Thank you, Catherine. I'd like to start by swearing in all potential staff witnesses for today's cases. When I say your name, please acknowledge that you are present, and then I will administer your oath. Keegan McDonald, Planning Staff Case Presenter.
Present.
Do you swear or affirm that the testimony you will provide in the evidentiary hearings of today's meeting will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Eric Hodge, Planning Staff Case Presenter.
Present.
Do you swear or affirm that the testimony you will provide in the evidentiary hearings of today's meeting will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Justin Rometta, Zoning Administrator.
Present.
Do you swear or affirm that the testimony you will provide in the evidentiary hearings of today's meeting will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Brittany Waddell, Assistant Planning Director.
Present.
Do you swear or affirm that the testimony you will provide in the evidentiary hearings at today's meeting will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Daniel King, Transportation Plan Review.
Present.
Do you swear or affirm that the testimony you will provide in the evidentiary hearings at today's meeting will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. As we jump into the agenda, I want to make one thing clear. In the board docs that was printed for the public, there was one error. Please note that the last case as listed in board docs is actually going to be the third case to be addressed today. That's Design Adjustment A-16-20. So that's actually third in today's list. With that, we'll move to evidentiary hearing 107 East Aycock Street. This is a variance, BOA-0026-2020.
Okay, we have two, and I'll say Todd Fisher is the property owner. We have two people sign up to participate in this case, Michael Birch and Ryan Johnson. When I call your name, please state your name and your address, and also please give your consent to proceed in the remote format. Michael Birch.
Hello, this is Michael Birch with the address of 4509 Creedmoor Road, Suite 302, Raleigh, North Carolina, 27612. and I affirm my consent to participate in this remote meeting platform.
Mr. Birch, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And Ryan Johnson.
Ryan Johnson, and I reside at 4126 Rockingham Drive in Raleigh. And I also give my consent for this remote platform.
Mr. Johnson, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Mr. McDonald, it's yours.
Thank you. So I will begin just by reading the legal advertisement and nature of request for this item. Whereas Todd Fisher, property owner, requests a 2.5-foot variance from the required 2.5-foot driveway setback set forth in section 2.2.7F of the Unified Development Ordinance to permit a driveway and parking area with a 0-foot sideline setback in conjunction with a detached house on a 0.16 acre property zoned R10 in NCOD located at 107 East Acock. So as you can see from this image, this request is pertinent to the construction of a detached house shown here on the lot, what appears as vacant, but construction is underway. And actually a portion of the driveway has already been poured, which I will get into in a later slide. But this is related to a 5-lot subdivision that was finalized back in 2018. The creation of this lot and its specific width is necessitating this particular variance request, and essentially they are looking for relief from the requirement that the driveway be set back 2.5 feet from the side property line. If you could advance 2 slides, Eric. So here is the property survey showing the home and the driveway. If you could advance 1 more slide. Here is just a zoomed in version. I think this might give you a better idea of what's being proposed. So the area outlined to the rear, that's kind of the parking pad adjacent to the detached garage. The majority of that's already been poured. What's in question today is really this the driveway portion to the right of the detached house when viewing it from the public street. And this particular driveway, as you can see, will directly abut the property line. The infill compatibility regulations require that it be set back a minimum of 2.5 feet. There are 2 exceptions that can be granted, just for your reference. Those are if it is a shared driveway, it can be adjacent to or encroaching on the property line. Also, if a new build easement is secured such that this driveway would maintain a minimum of 5 feet separation between any other improvement on the neighboring property. However, in this case, neither of those specific circumstances is applicable. They are looking for just to build the driveway as proposed without any of those conditions. And staff, relevant to the specific variance criteria, only had a comment related to number 4, which speaks to the spirit, purpose, and intent of these regulations. They are contained in the infill compatibility section, specifically because there's an understanding that lots in an infill setting might be a little bit more sensitive and might have more built context that they have to accommodate. And so really the intention behind requiring the driveway to be set back some distance from the side property line was threefold. It was to ensure adequate spacing so that persons exiting their vehicle once parked would not encroach onto the adjacent property, or any fencing or screening that may be present at or near the property line. Secondarily, this regulation was intended to provide a little bit more impervious surface such that runoff from the driveway could be captured. And third, it was also intended to hopefully limit root disturbance if there were trees in the vicinity of the driveway. So that really speaks to the intent of the regulations. If you could advance 1 more slide, Eric. This is a graphic just showing as you can tell from this image, the blue is the proposed paved area that will be closer than that 2.5 feet from the property line. Again, the back parking area has already been paved, and I think there's an image that the applicant will present to show that a little bit more clearly. But this is the scope of the request. And that actually concludes my commentary. If not, the applicant, I believe, has some slides for you as well.
Okay, thank you. Board members, any questions for Mr. McDonald? No one? Okay, thank you. We will move along to Mr. Burch then.
Great. Good afternoon, Chairman Swink, members of the board. This is Michael Birch with Longleaf Law Partners. And with me today also is Ryan Johnson with Revolution Homes. I'm going to try and introduce the evidence that's needed, but wanted Ryan to be available for any questions. And just before I get into the presentation, Mr. Chair, I just would submit into evidence our application and documents as in our presentation into the record.
Thank you.
So as Keegan mentioned, this is a request for a 2.5-foot variance to the driveway setback standard in UDO 2.2.7F. And the purpose of this is to permit a portion of the driveway. If you advance 2 slides, you've seen, next slide. Yep, there you go. This slide before, that portion of the driveway that's in blue, in order to serve the garage, detached garage and parking pad in the backyard with a driveway of a reasonable enough width to not create a safety issue along the side of the house there. Just a little background, as was mentioned in our application, and I think Keegan touched on it. This lot was created as part of a subdivision with case number S3815, which was approved October 5th of 2015. And the lot was recorded with a plat on March 2nd, 2016, and that's in Book of Maps 2016, page 315. As shown on this survey, the lot is just 47.77 feet wide, which is just over 2 feet more than the minimum lot width in the R10. It's important to note that there was no driveway setback applicable to this portion of the property when the lot was created. At the time that this lot was created, to where the lot line meets the property, the right-of-way line, it was only at that point, and then the driveway could kind of curve back in and run along the property line. So it only applied to kind of the driveway cut area. So that 2.5-foot setback for this portion of the property was not effective until April 3rd of 2019 as a result of text change TC 717. Let's see, if you could advance to the next slide, please. So this is week or week before of the on 107 East Aycock. You can see that front portion of the driveway has been poured. You can kind of see just beyond that truck some area that looks like kind of dirt right now. It has not been paved. And that is kind of the area and the portion of the driveway related to this variance. The next slide is the house just immediately to the left, 105 East Aycock. And you show this because it has a similar driveway condition where the driveway runs along the right side of the house and essentially adjacent and along the property line with no setback relative to 107. And if you go to the next slide, this shows 109 East Aycock. So there, kind of on the left-hand side of the picture, you can see the portion of the 107 driveway that is not yet poured. And I would just note that the driveway for 109 East Aycock also runs along the right side of the house with no side, no 2.5-foot setback on the right-hand side. And all of these lots were a part of that same subdivision, case S3815. I would note that the vegetation that you see in front of 109 East Aycock is kind of right in front of the house. And so kind of in that area where that poor driveway exists. And so, which complies with the setback. And so the area beyond that, the driveway for which we're seeking the variance, is past that vegetation. So that just goes to one of the spirit, purpose, and intent statements that staff identified. So it should not affect that vegetation there. And if you would just go back, maybe back to the slide that shows the blue portion of the driveway. I'll also note, this is as it relates to stormwater, that the house at 107 Aycock, the lot, sits lower than both adjoining lots, so 105 and 109. So stormwater from the proposed driveway will not run onto the adjacent property at 109 East Aycock. It will, in fact, hopefully be caught by that grass strip, but to the extent not, it runs down the driveway. It actually will go to an existing inlet that was installed as part of this subdivision near the right-of-way where 107 and 105 have their common boundary line. I'll touch on that later. So just wanted to touch on the standards. Again, unnecessary hardship. Without a variance, only about a 7.5, 8 foot wide driveway would be permitted. It's important to note that that would be kind of right along the side of the house, that 48.5 foot run of the house there. So a very kind of tight area, really not of a sufficient width to permit the vehicle to kind of safely pass through. The existing house width is only about 30 feet. So again, not an overly wide house, particularly for this area. And that we've complied with the other setbacks on the other side yard, including one that was adopted after the lot was created for mechanical equipment, which again caused the house to be pushed a little to the east. Again, these conditions are peculiar to the property, given its narrow width, and the fact that the lot was created, approved, and recorded with these dimensions prior to the effective date of that driveway setback regulation. And I'll also note that the adjoining lots, 105 and 109, were sold in 2018 prior to the effective date of this regulation, so there wasn't an opportunity to kind of recombine and shift lot lines. And it's not a result of the current owner. Lot was created prior to the purchase of this lot. So wanted to touch on the factor consistent with the spirit, purpose, and intent of the ordinance. In the one of the intents of the infill regulations is to kind of provide for compatible development with the adjacent lots. And again, as I went through those pictures, you'll see that that driveway condition is something that is common along this block face. I will also note that we have support from the owner at 109 East Aycock, Miss Lynette Ann Valacourse. She did provide a signed, notarized letter of support, but that was not provided in time for it to be included in your packet and in the record, but I at least wanted to make you all aware of that, and that is the owner adjacent to this driveway. With regard to stormwater, as I mentioned, 109, the adjacent lot sits up above 107. So there's really no concern about water drainage going from 107 to 109. And we are providing that 3 foot wide grass strip, and the stormwater is being directed to an inlet near the street, near 105 and 107 where they meet. I will also note that to the north of this property, and a lot of these properties in the subdivision, there's an apartment complex that was developed prior to stormwater regulations. And these lots receive quite a bit of stormwater from up the hill. And so we think that providing this driveway here to the property line will also prevent the creation of kind of this, it comes down the east side of this lot. So it'll prevent the creation of kind of a wet area because this area doesn't get a lot of sun given the height of the house. And it will help direct and carry that stormwater along the side of the house to that inlet. So again, we think that it's a net positive from a stormwater standpoint. Again, for Keegan mentioned result of or the idea of a no build easement to maintain that 5-foot setback. I'll just note these properties are zoned R10, which imposes a minimum 5-foot setback. So there will be, maintained a 5-foot setback on the 109 property to the east. So the intent of that is being met as well. So for those reasons, we would ask for the board's support of this variance, but happy to answer any questions the board may have.
Okay, thank you. Board members, any questions for Mr. Birch? This case? Anyone? Staff, do you have any additional information you would like to offer?
Not at this time.
Okay. Is there anyone here who wishes to speak in support of this request? Anyone here wishing to speak in opposition of this request? Let me go back to the applicant, Mr. Birch. Anything more you wish to add?
No, sir. Thank you.
Mr. McDonald, I think you've already said nothing further. Is that the case?
That's correct.
Okay, board members, one last chance. Okay, let's close the evidentiary hearing. We'll bring it to the board for deliberations and a motion.
John Coons, motion to approve.
Thank you, Mr. Koontz. May I have a second?
A second.
Mr. Mile? Thank you. We have a motion to approve and a second. Any further discussion? All in favor, we'll have a roll call vote. Mr. Puccini?
Thank you, folks. Mr. Coons?
Approve.
Thank you, Mr. Mile.
Approve.
Rudisell? Thank you, Mr. Sutton.
Approved.
Thank you. That makes 5.
Thank you very much. Okay, let us move along to our second case. This is 7070 Leesville Road. Energy Progress is the property owner. This is a special use permit, BOA-0049-2020.
Okay, and we have 4 people signed up to participate in this case: Thomas Johnson, Joseph Smathers, Christopher Bernardo, and Jeremy Wooster. So when I call your name, please state your name and address for the record and confirm your consent to proceed in the remote format. Thomas Johnson.
This is Tom Johnson. My address is 301 Fayetteville Street, Suite 1700, Raleigh, North Carolina 27601, and I'm the attorney for the applicant.
And can you give us your consent to proceed?
I do consent to proceed in this format. Sorry about that.
Okay. Mr. Johnson, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right. Joseph Smathers.
Yes, this is Joseph Smathers, 7500 Cadbury Court, Raleigh, North Carolina, and I consent to the platform.
Mr. Smathers, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Christopher Bernardo.
Hello, this is Christopher Bernardo, address of 9887 4th Street North, Suite 100, St. Petersburg, Florida. And I do consent to proceed in this format.
Mr. Bernardo, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, nothing but the truth?
I do.
Excuse me, Mr. Chairman. Mr. Bernardo, could you repeat your address one more time, please?
Sure. 9887 Street North.
I'm sorry, something blinked in. It's something street north?
4th Street North, and that's Suite 100, St. Petersburg, Florida.
All right, thank you so much, sir.
No problem.
All right, and Jeremy Wooster.
Yes, I'm here. Mine is 922 Sugar Hollow Lane in Wake Forest, North Carolina, 27587. And I agree to the online meeting.
Okay, Mr. Wooster, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I affirm.
Thank you. Okay, Mr. McDonald again.
Okay, thank you. So I will begin by reading the nature of request. Whereas Duke Energy Progress, Inc., property owner, requests a special use permit pursuant to sections 633D2L and 1029 of the Unified Development Ordinance to construct a 251-foot telecommunication tower on a 5.44 acre property zoned R4 located at 7070 Leesville Road. The SUP request seeks to modify the following standards. 1, the required 251-foot setback from the adjacent residential district set forth in UDO section 633D2D to allow a 65-foot setback from the property to the north. Property identification number 07878374775, zoned R10, and a 208-foot setback from the property to the east, property identification number 07879244683, zoned R4. 2, the street protective yard requirement set forth in UDO section 633D2F, and 3, transitional protective yard requirement set forth in UDO section 6. So again, this is a special use permit request to erect a telecommunications tower, as stated in the nature of request. The property is residentially zoned. It is also adjacent to other residentially zoned property to the north and to the east. It's bordered by Lynn Road to the south and Leesville Road to the west. Authority granted in Section 6 of the UDO related to telecommunication towers. The first set of authority is related to the modification of setbacks, and that's set forth in Section 633D2D6. It states that the board shall be able to grant a lesser setback than what's otherwise required, in this case 100% of the proposed tower height, or 251 feet, if it can be shown that the modified setback will not be injurious to property or improvements in the affected area. Further, this section of the code permits the Board of Adjustment to approve the construction of any tower which does not meet the above standards if evidence is provided which demonstrates that reasonable effort has been made to lease space on an existing tower, or that no existing tower will technically satisfy the applicant's specific needs. Relevant to both of those criteria, the applicant has submitted some documentation for your review. I wanted to go into kind of some of the specifics related to the setback and also other relief sought to the transitional and street protective yards. Eric, if you could advance 2 slides, please. So this is the proposed survey or site plan for the tower. So as you can see, there's an existing substation on the property. There will be a driveway or access constructed, taken from the existing access off of Leesville Road, that will take you to this proposed telecom tower. It's in the top section of the slide there, or excuse me, of the image. So what's of note here and what's being requested for relief? At present, it's a proposed 251-foot tower. I believe the applicant will be bringing forth a potential condition related to the height, but I wanted to touch on two factors. First is the setback from the northern property line. As you can see here, the proposed setback is only 65 feet instead of the required 251, and the setback from the eastern property line is shown as 208 feet. So they're seeking relief for a reduced setback from both of those adjacent residential properties. The other portion of the requirements that they are seeking relief from are both the transitional protective yard, which is to adjacent residential property, and so that would be the properties to the north and east. Under the use standards, there is a requirement to provide either a type B1 or B2 protective yard. Essentially, what that consists of is spatial buffering, also a wall and or fence, and then specific types of plantings. So basically landscaping and screening between the telecom tower and those adjacent properties. I believe they've included a condition to allow the existing vegetation to stand in for those protective yards, but at present that is their request for relief from those requirements. The other protective yard is a street protective yard, which would be adjacent to Leesville Road. This is, again, a requirement for certain types of buffering and tree plantings adjacent to the street. And they are also seeking to rely on existing vegetation to serve as a buffer between the street and the telecommunications tower. Eric, if you could go back 2 slides, please. I just wanted to pinpoint this slide again in reference to those protective yards, because you can see the existing vegetation that adjoins the property lines to the north and to the east, and also adjacent to the street along Leesville Road. And there is also power lines or transmission cables that run along the eastern part of the property as well. So I just wanted to point out those existing conditions in relation to their specific request. Eric, if you could advance 2 more slides. That's good, thank you. And so relevant to the special use permit standards that are used to evaluate these types of requests, in the report you can see the applicant's responses. Really the only specific comments that staff had relevant to the application was related to special use permit standard number 5. That states that any adverse impacts resulting from the proposed use in the affected area will be effectively mitigated or offset, or else the special use permit should be denied. We understand that they are looking to use existing vegetation as a buffer. However, the transitional and street protective yards are very specific in what they require, and as such, there's not been additional information provided to justify, not providing those specific types of buffering, and that's really our comment related to whether or not adverse impacts will be mitigated. Just that all that's been provided thus far is that condition, but not really a justification as of yet as to why those protected yards could not be provided for this property. Outside of those 2 criteria, I don't really have any further comments. Eric, if you could advance 1 more slide. This just shows an elevation of what the tower will look like from a street level perspective, just for your reference. And as I stated, that really concludes my commentary on the application. Staff is really only looking for further justification as it relates to the street and transitional protective yards with this tower. And I do want to note that the applicant has a presentation that they'll be providing, and also, I believe, a more refined set of conditions related to this proposal as well.
Okay, thank you, Mr. McDonald. I do have one question regarding the street and transitional protective yards. If we offer relief in that regard, are there requirements that they would have to maintain what is in fact left to serve in that purpose?
I believe that could be made part of the condition, but maybe Catherine could offer some feedback in that regard, and or potentially another staff person.
So if you grant relief from that requirement, I guess it depends on what the relief granted is. I mean, if you grant relief completely from the requirement, then there is nothing. When staff goes in to review the application, when they come in, they will review it with whatever relief you grant. So I don't know if there's anything Keegan or Justin or anybody else with staff that any other protective yard or buffer requirements in the UDO they would have to comply with. But with respect to this particular UDO requirement, the staff will review it with whatever type of relief is granted.
Okay, thank you.
Does that answer your question?
Yes, it did. Thank you very much. Board members, any questions from anyone else?
This may be, John Koontz, maybe a question for Catherine. So who reviews the appearance of a 251-foot pole? I mean, is that an appearance commission thing? I know we're not doing that today. I'm just out of curiosity, who governs that?
So they're governed by the UDO and whatever UDO standards are applicable.
Okay.
I would refer to Justin if there's any, or Keegan, if there's any UDO standards that are specifically related to appearance that maybe you're not seeing as part of the special use permit standards.
This is Keegan. I'm not aware of anything related to appearances specifically. The majority of the standards relate to technical aspects of the construction of the tower or these types of setbacks and protective yards.
I see that Justin Rometta has his hand raised. I don't know if that means that he can't unmute himself. So maybe Laz, can you unmute Justin and see if he has anything to add?
Thank you, Laz. Yeah, I'm sorry, I don't have the ability to unmute myself. Keegan's correct. There are no appearance-related standards other than landscaping and screening, and the review is an entirely administrative one that's done by planning staff.
Okay, that's just curious. It seems a little bit of exposure for the city of Raleigh there, but we'll save that for another discussion. Let's dive into the presentation. Thank you.
Okay, thank you. Any other board members? Okay, Mr. Johnson, let's hear from you.
Thank you very much to the board, Mr. Chair and the board. I'm Tom Johnson. I'm with the law firm of Williams Mullen at 301 Fayetteville Street, Suite 1700 in Raleigh, here on behalf of the applicant. I would ask up front that the application and documents submitted with the application and my presentation be admitted into evidence in support of our application.
Okay, thank you.
I do want to go ahead and just address up front what we're doing. The ordinance doesn't allow for a variance process to allow relief on a setback for a tower below 251 feet. So our only choice was to apply for a tower 251 feet in height and use the special use permit process to be approved. Because all the applicant really seeks at this location is a 100-foot tower, which is all that is necessary for the service that Verizon Wireless wishes to provide at the site. So our intent in going forward is to agree to a specific condition that the tower be limited to 100 feet in height, and that would be fine with us as a condition which is allowed as part of the special use permit process. It can certainly, the approval can be conditioned. So I wanted to make that clear up front, and as I get through my presentation, you'll kind of see what the situation is. With respect to the chair's question about vegetation, if we seek relief from those protective yards and the street protective yard, transition protective yard, it would be our intent to agree as part of that condition to leave the remaining, the existing vegetation in place. And as you'll see, there's quite thick and mature vegetation in place. We would leave that in place and agree to leave that in place, or we would have to otherwise meet the requirements. So we're happy to agree to that as a condition as well. So I just wanted to address that up front. In addition, I have with me Joe Smathers, who's a real estate expert. I have Chris Bernardo, who's with PeakNet, who will be in charge of constructing the tower on the site, and Jeremy Wooster, who's the engineer for the site, who designed the drawings that you have before you. I anticipate probably only having Mr. Smathers step in and testifying, and the reason being is the impact statement that was submitted as part of the application was signed by an associate of Mr. Smathers, Graham Herring, and Mr. Herring had a medical procedure today and could not attend the hearing, so Mr. Smathers can speak to that impact statement, and I think that would be a good idea for the record. So I just wanted to let you know that, and let you know that Mr. Bernardo and Mr. Wooster would be available to answer any other questions the board might have. So at this point, unless there are any questions at this point, I'll just proceed to my presentation.
Why don't you go ahead with your presentation, Mr. Johnson?
Absolutely. So if you could pull my presentation up. Again, this is for a special use permit for a telecommunications tower on Leesville Road. This is the aerial. And this is similar to the aerial that Mr. McDonald presented earlier. This is an existing utility substation with high voltage power lines to the right-hand side or the eastern side of the site, and vegetation meant to screen that on all of the other sides. I will tell you, we explored the opportunity to put this tower toward the Leesville Road side of the site because the setback when you're on a street frontage with the church is located opposite was much less. But as you will see in my slides coming up, this site has steep elevation on the Leesville Road side, such that there was not a spot at which the tower could be constructed on that side of the site. So the only really level site that isn't dealing with a severe drop-off is the site to the north. And as you see, there's a lot of thick existing vegetation. If you could go to the next slide. And this shows, again, this is similar to what Mr. McDonald showed. We've pushed the site back so that to get as much setback as we can from the adjoining property to the north, which is 65 feet. There are apartments to the north, and those apartments are the nearest building on those apartments is approximately 171 feet from where we're proposing to put the tower. So there's no building that's close to where the tower is going. So that's how we're placing it on the site. Again, it's very compatible with the existing high voltage power lines and substation that's on the location. If you go to the next slide. Again, this shows I'd forgotten I had this slide included. It shows 171 feet to the closest structure to the north. Next slide. Okay, this is the view from Leesville Road. As you can see, there are significant trees on that side of the site, and as you can see, it slopes upward toward the substation site. And basically, Leesville Road proceeds down toward Lynn Road at this location, Lynn Road being to the right hand of this slide. Next slide. This is a view from Lynn Road, again, very significant pine trees as a vegetative buffer for Lynn Road. This would be the furthest from the site since it's on the south end. The tower itself would be much further on the other side. And this is a view of the easement with the high voltage power lines that exist on the eastern side of the site toward Lake Lynn Park. That's just to the right of this power line and to the east of it. Next slide. And this is the entrance road off Leesville Road, again, heavily vegetated on either side. But this is the road by which access would be to the site. Next slide. This is a letter from Verizon, a radio frequency engineer that's part of the record. Basically, this site, as he indicates, for additional capacity. Tower sites in this day and time are going to be either for coverage, that is where you just don't have existing wireless coverage in your area, or they're for capacity. And in urban areas, you reach capacity needs about as often as you do coverage needs at this point in the development of technology. And what that means is There are existing sites that Verizon has in the area, but as those sites get more busy and become more full, you basically have to offload some of that traffic to an adjoining tower site in order for the site to work appropriately. Basically, it gets so full that the signal gets weaker as more people use the site, and you may not be able to, even your call may be blocked because the site reaches its capacity and cannot handle the calls. But there's no existing tower in the area, which is towers being proposed, as Mr. Singh indicates, that will technically provide the needs or satisfy Verizon's needs, which is one of the conditions to allow for the board to modify the standards in the ordinance. Next slide. This is basically showing existing towers in the area. Basically, on the site that's near Lake or Lynn Road and Glenwood Avenue, that's Verizon's existing tower on that end of Lynn Road at Glenwood Avenue. That's a site that is extremely busy and is having capacity issues. Also, Verizon has another site, if you look to the right, where Lynn Road intersects Creedmoor Road, which is the yellow road on the right-hand side of the slide. That's where Verizon's other site is in the area. And as you can see, this site, which is where you can see the lake in the middle and you can see the intersection of Lynn Road and Leesville Road, that it's almost exactly in the middle between these two towers, which is why it's a really good location to meet the technological needs that Verizon has for a tower at this location. The other two tower sites that are shown here are just other existing tower sites on which Verizon is not located, but it just shows that there's significant distance between these sites. It's greater than 1,500 feet as spoken to in the ordinance. Next slide. Again, we also submitted an engineer sealed statement in the record that this tower will be designed to stay on site. And even though it's a reduced setback of 65 feet, these towers are designed, and Sabre Industries will be the company that will actually produce the tower. They'll produce it in a way that if the tower does fail, it's going to fold down and it will not encroach onto the adjoining property. And that can be done, and those towers are engineered in that way regularly by the industry. Next slide. And these are Mr. Smathers' qualifications. And if I may, let me introduce Mr. Smathers and get him to speak to the impact statement that Mr. Herring prepared that's part of the record. Mr. Smathers, if you could introduce yourself.
This is Joseph Smathers, 7500 Cadbury Court, Raleigh, North Carolina. Mr. Chairman and members of the board, as Mr. Johnson has indicated, Duke Energy Progress has asked me to review the proposed tower location. To make certain that construction of the facility at the proposed location will have no negative impact on the value of surrounding properties. I've been engaged in the business of real estate valuation, brokerage, and development for over 50 years, and a licensed North Carolina real estate broker for 47 years. I'm a member of the National Association of Review Appraisers and a senior valuer with the International Institute of Valuers. I've examined over 700 proposed tower sites. As in Mr. Herring's report, also my review of the site and surrounding properties, and contained in other reports and information that I've reviewed, the evidence indicates that the construction and operation of communication towers does not have an adverse impact on property values or the natural progression of planned use and development of the surrounding areas. Also, with the selection of this site surrounded by a heavy tree line, extensive vegetation, and with limited visibility from any adjacent housing, it's my conclusion that the proposed tower will not injure the value of surrounding properties and will have no negative impact on the future development of the surrounding properties. And I'll be happy to answer any questions. Thank you.
Thank you, Mr. Smathers. And I don't know if anyone will ask any questions of him now or wait until the end of the presentation, Mr. Chair.
If you want to wrap your presentation up, then we'll open it up to the board for questions.
Sure. Absolutely. Next slide, please. Again, this is the provision that Mr. McDonald spoke to. There's no existing tower that would technically satisfy the applicant's needs, and which would justify reducing the standard so that we could be 65 feet from the northern property line. The other property lines, if you reduce the tower height to 100 feet, we would meet those setbacks, so there would be no problem with that. Also, as far as the protective yard and transition yards, I mean, to us, it didn't make sense to remove perfectly good vegetation to then put in the protective yard. So we just like to keep that vegetation. It's quite mature, it's been there a while, obviously put in there when the substation was put in, and we'd like to be able to just maintain that. There will be a fence around the compound, so there is a fence that will exist around the site. Next slide. Again, Mr. Smathers spoke to this, that the use will not be injurious to the property or improvements in the affected area. Next slide. In summary, the site is technologically necessary in order to provide service to the community. There are not many sites in this area of Raleigh that are as good as this one to provide service to the area. It's predominantly a residential area, and the nice thing is there is a substation there where a tower can be put so that it's a utility use consistent with the other utility use that's already in place. The setback goals are met because the tower will stay on site. Because of the, again, it will be designed to stay on site as indicated by the certified statement from the company that will construct the tower, Sabre. The existing vegetation meets the intent of the street protective yard and transition protective yard. Again, that vegetation was put in when the substation was put in. It will provide that protection for the adjoining properties. And again, we are open to a condition in allowing relief from these provisions to leave the existing vegetation in place for the site. Again, this is consistent with the existing infrastructure of substation and high voltage power lines. And as Mr. Smathers testified and Mr. Herring's report indicates, this use as a tower at this location will not be injurious to the property or improvements in the affected area. That concludes my presentation. I have Mr. Smathers, Mr. Bernardo, and Mr. Wooster available for any questions the board may have, and I'm available for.
Mr. Johnson, board members, any questions for Mr. Johnson or Mr. Smathers or others in his witness team?
Yes, this is Justin Sutton. Can you hear me?
Yes, sir.
Okay, I had a question for Mr. Smathers. Was your report included in the presentation, or can we get a copy of that report? You conducted a survey of, was it a residential survey to kind of gather the opinion or
This is Tom Johnson, if I may. What we did is because Mr. Herring could not be available, Mr. Smathers basically is confirming Mr. Herring's report. So he's confirming the accuracy of that report. And also, I think what Mr. Smathers was referring to, and he can affirm, but I think it was that he made a site visit. He actually himself went out to the site so that he could be able to speak to it as Mr. Herring did.
is that report even admissible? Or did you seek to admit that particular report?
Yes, I'm seeking to admit that report because it is a report from a real estate expert, but because the expert could not be present, I'm relying on the testimony of Mr. Smathers that reaffirms that report. You can block Mr. Smathers' testimony as opposed to the written report, in lieu of the written report.
Sorry, this is Keegan McDonald. I just wanted to comment that the report, I believe they're referring to, the impact statement, was included in the materials on board docs. If you're looking at the staff report, I believe the impact statement begins on page 21 of the PDF.
Okay.
And Mr. Sutton, I see where you're going with, it was included in board docs, and typically a witness would, the person who wrote the report would be here in order to
Correct.
authenticate and submit that report into evidence. And because this is quasi-judicial, it would be hearsay that something in quasi-judicial, it's not necessarily a hard rule that you can't have it submitted with part of your materials. It's just the question is the board's reliance on the testimony for the matter for which it's being submitted. And I believe what Mr. Johnson is stating is that Mr. Smathers' testimony is intended to say the same thing from another real estate expert, if that's correct, Mr. Johnson.
Yes, this is Tom Johnson. Yes, that's correct. Mr. Smathers basically is doing the same thing via testimony rather than the written report. But the other thing he does, which again, since this is quasi-judicial, would be appropriate, is he reaffirms that what Mr. Herring said was accurate. But he also did his own independent assessment. And the requirement would be only that we have one expert. And because we had expert testimony under oath, that is Mr. Smathers, that would take the place of needing a written report.
Justin, does that answer your question about the report?
Yes, it does. It does. As long, yeah, I guess as long as Mr. Smathers qualifies and.
I believe Mr. Thompson was tendering him as an expert. I don't know if you want, and gave his
credentials.
Yeah, and I don't know if you want to have officially have Mr. Swink make the ruling or to officially tender him as an expert.
Yeah, and I would, and I did not, Catherine, and I apologize for that, but I do tender Mr. Smathers as an expert, and if the board wants to rule on that separately, they're fine to do that. His qualifications are part of the record.
And as reading the qualifications as presented, I will accept on behalf of the board his expertise in this area. Mr. Smathers' expertise.
Thank you, Mr. Chairman.
Thanks, Justin, for pointing that out and making that clear.
Yes, thank you, Justin. Any other questions from board members?
Yeah, this is John Coons. So the request is for a 251-foot tower, but I also heard a couple times the potential request or settling of to a 100-foot tower. So what are we doing here? Is that something that is open for a contingency, or can the applicant talk about is the need for 251, or is it okay to go with 100 and that would satisfy the demands of Verizon and the needs of the community?
Yes, Mr. Coons, the 100-foot tower will satisfy Verizon's needs to provide the service in the community. So we're fine to condition the height. Just add as a condition to our request that it be limited to 100 feet, or if the board wants to go higher, that's fine, but 100 feet will satisfy Verizon's needs at this location. And we prefer to be no taller than 199 feet, because then we'd have to light the tower, and we would not prefer to light it in this area. So, but again, we're willing to condition it to 100 feet, so that point becomes moot.
Okay, I got one more kind of conditional contingency. So we talk about the term existing conditions, and one thing I know from my experience is existing conditions don't always last. And so what happens, there are pine trees there. What happens if the pine beetles come in there and we've got the pine population decimated? What happens to those existing conditions? And maybe that's a Catherine comment. What do we do about kind of governing those quote unquote existing conditions in those transitional yards? What are we doing there?
I think if you wanted to impose a condition that requires the preservation of existing conditions, to specify exactly what those conditions are. So I don't know, Mr. Johnson, if you are able to advise to the board what the existing conditions are to refine that condition so that it becomes more enforceable. I think that's sounds like what Mr. Kent's is touching on.
Sure. I'm not a landscape architect, so I don't know it, nor am I an arborist, but I know that what is existing there, it may not last as long as a 100-foot tower. So that's the concern, and I know you want to shield it as well. So how do we come to an agreement on that is really the question.
This is Tom Johnson. I'm happy to agree to a condition that we will maintain and or replace any of the vegetation that exists.
Okay.
Or if we can't, we'll otherwise comply with the street protective yard or the transition protective yard.
I'm fine with that. Is that not specific? Is that specific enough, Catherine? What do you think?
One thing
And
I
know
would recommend, and I would defer to also plan review staff and Justin and Keegan. And you might want to maybe, if it's a condition that says, something where you need to submit to the city a plan or a rendering of what the existing conditions are at this time.
Okay.
Typically that's done, ideally we would have it now, but you could make a condition that, within X amount of days following approval that they submit to city staff a copy of what the existing conditions are more specifically so that can be maintained.
Okay.
And I would kind of defer to staff on how they would want to handle that.
Yeah, you see where I'm going with it. We'll get to that when we deliberate. Thank you.
Thank you, Mr. Coons. Other board members?
Yeah, I have a question. This is Steve Kinney. I've heard a lot of statements of how the value will not be impacted any of the surrounding properties. I think Mr. Sutton had a similar question. And I took the time to read the impact statement. And it states that in general, these types of towers are not the type of use which is so intrusive as to have an inherently negative impact on surrounding properties, and it continues. So what I'm wondering is, are y'all attempting to maintain that this is a particular type of tower that won't have a negative impact while other similar towers do? Is that your contention?
Joe, this is Tom Johnson. Joe, can you speak to that, please?
Yes, I can. No, sir. This is not a different type of tower at all. And what we have found is that the towers themselves that are being built today are not injurious to property values. So,
right. And Mr. Smathers, I completely understand that claim, but I'm not finding particular evidence for that in your actual impact statement. That strikes me as particularly convincing. What is it about a tower how would that not be a negative impact? If that apartment developer to the north wanted to redevelop his property, surely having a 150-foot pole next to his site would not be good for him or her.
If I may, could you go back to, on my slide, there was a slide about the power line easement. Could you go back to that? It actually shows a picture of it. It's pretty close to the beginning. There you go. I think part of the point too that Mr. Smathers is making is there are already existing high voltage power lines that are there. This is a single pole tower, and if we limit it to 100 feet, it's not going to be materially different from what's already there. So that's not going to change. So it's consistent with the other infrastructure that's in place, and whether the apartment owner does something else or not, he's still going to have those power lines that are there right next to where this tower is going. And this is a single pole tower. I mean, those are actually, double pole, high voltage power lines with cross members and a lot of wires coming around them. And Mr. Smathers, can you reaffirm that that's part of where you're coming from, is that this is already has a lot of existing infrastructure in place?
yes, it is. And it is telecommunication towers today have proved to be just normal as telephone poles in a lot of cases. People are accepting them because they realize that they really need them. And it has to do with different types of studies that we have done, empirical studies. We have found over time that there has been no diminution of value with these towers. The adjacent subdivisions that are our properties.
And the other thing that Mr. Smathers was referring to is oftentimes the issue of, do we have good coverage, especially in this time of pandemic and people are working from home? That can be of more value than the appearance of the tower, is the fact that you've got good coverage. And with apartments and a lot of the residential surrounding this area, those individuals will, more likely than not, they may actually improve the value of the properties because they know they've got better coverage.
I don't find that convincing.
Yeah, I would concur with Mr. Mile there.
Yeah, but the other part, well, that's one of the things that is weighed in and what Mr. Smathers is speaking to. But the other thing is they're just existing towers that are already there. that aren't going anywhere because and this tower site, as you can see on its location, directly adjoins the easement where these existing towers already exist.
Right, and I don't know if the board considers me a subject matter expert or not, but I am an apartment developer, and I would consider this a negative impact to this for my site.
Forgive me, who was speaking, please?
I would.
I don't know if that's allowed or not, but you can strike it if it's not.
No, I think that was Mr. Kenny speaking, and I would say too a couple things real quick. Make sure, Justin, since we can't see you visually under this new law, please make sure we can just state your name when you speak, just so we can get you clear with Mr. With our clerk. With respect, there you are. See you now. With respect to your question about the experts, in order to prove certain things such as the value or the impact of property or a proposal on adjacent property values, you are required to have a competent expert, which you have to have an expert in that area. Now, with respect to you can always, as the board, question the expert, cross-examine as you will, and question the expert, and that's completely fine to do. What case law says is that you would only to be competent evidence, it would have to be from another expert. So, for example, counter evidence would be from another expert. There's nothing wrong with you asking questions about the report and their evidence and the testimony they're providing.
Cool. Thank you.
Thank you. This is Mr. Swink. A question. This is a Duke Progress Energy site. What is occurring on the site at this time?
Let me have Chris Bernardo speak to that, who's with PeakNet. This is Tom Johnson, by the way.
Okay. Mr. Bernardo?
I don't know if what I can say is this: it's an existing Duke substation, so it's your typical substation that you see throughout the community, and these are high voltage power lines that transmit the power to and from that substation.
Right.
Hello, this is Christopher Bernard. I'm sorry, I was muted.
Yeah.
And could not unmute myself.
Go ahead, Chris. And this is Tom Johnson again. Chris, can you just explain what's existing on the site?
You basically covered it. This is currently an existing Duke Energy substation, along with transmission lines that are on it right now.
Okay. Thank you. Okay. Other board member questions?
Yeah. To that point, this is Marvin Butler speaking. So, how high is the current existing facilities there now? Because I know this is a 100-foot tower.
Chris, can you speak to, or Jeremy, can you speak to how tall those existing power lines, transmission lines are?
It would be something I would need to research to see how tall the transmission lines on the other side is. It is something I can look up.
Okay. Is this Chris?
It is. I'm sorry. This is Christopher Bernard.
Yes. How about Jeremy? Jeremy, do you have an idea approximately the height of those? Jeremy Wooster.
Yeah, I agree. I'd have to go look. Like, my guess would be somewhere in the range of 60 to 80 feet, but I'm not sure how tall they actually are.
Okay. And also, Mr. Chairman, if I could follow up with another question from Catherine and John's comments about the protective buffer yard and transitional setbacks as far as the conditions, if this is approved, that I guess to those conditions to be added, that it would be maintained throughout the life expectancy of the tower. Ever how staff could write that up.
Okay. When we get to a motion, we'll verify that language. Thank you.
Okay. Thank you.
Other board member questions? Okay, let's take it back to staff. Mr. McDonald, do you have any follow-up questions from what you've heard?
No, I did not have any follow-up questions. I just wanted to add, because there's been a fair amount of discussion revolving around the potential condition, that potentially Justin Rometta could provide some insight because of his experience with the current planning division about how the existing trees on the site or those existing conditions could be verified, such that, trees aren't removed between here and permitting for the tower. But I believe that's something that should be clarified, and hopefully Justin, or even maybe Eric with their expertise, could provide some insight on condition wording. But outside of that, I do not have any other questions or comments at this time.
Okay, great. Thank you very much. Okay, let us go to the public. Anyone else here wishing to speak in support of this request? Anyone wishing to speak in opposition to this request? We'll go back to the applicant. Any further thing you wish to add based on questions we've asked or anything you've heard?
Yeah, I would like to, this is Tom Johnson. I'd like to once again reemphasize what Catherine said. When we present a real estate expert, the case law is clear that that expert's testimony would stand unless there's an expert to the contrary. So, being no expert testimony presented to the contrary, then Mr. Smathers' testimony would stand as an expert in real estate in terms of, and testifying in terms of the impact of the tower as proposed on the site. I will reemphasize again that we're fine to limit it to 100 feet because that would be more consistent with the adjoining power lines and transmission towers that are there. It will be a monopole tower as shown in the documents, which is a single pole tower. So we'd be willing to do that. And in terms of the protective yards, we're willing to either, and we could word it this way, that we will preserve the existing vegetation, and we can find a document that surrounds the site, but for constructing the compound. But we will preserve that or replace it, or if we can't, then we'll otherwise meet the street and transition protective yard requirements. But we'd like to have that as an option in the event that we can't replace them to the degree to meet, to keep the existing vegetation.
Okay.
And that's all that I have.
Thank you. Staff, again, anything further?
Well, I want to make sure Justin Rometta if he has anything to add. I don't know if he can unmute himself or not.
I can. This is Justin Rometta. As to the landscaping, I would recommend that the applicant just submit the plan with their permit application whenever they submit that to development services staff. I think it's reasonable if you wanted to ask them that they had the plan prepared and signed off on by a licensed architect or surveyor within a certain amount of time. I think that's something you can do. But I think as far as submitting it, I think submitting it with the permit application would be fine. I would also suggest that you include some allowance for the removal of dead, unhealthy, or diseased landscaping. That language is used elsewhere in the code. And typically, when required landscaping is removed for those reasons, it's required to be put back within 180 days. So that is language that is used elsewhere in the code that you may want to mirror.
Justin, what were those? You said dead. What were the other two things you said?
Dead, unhealthy, and diseased.
Thank you.
And this is Tom Johnson. I would consent to that. I do want to, Mr. Chair, if it's appropriate. I think Mr. Bernardo has been able to determine the height of those power line, the poles related to the power lines. If he could speak on the record.
Hello, this is Christopher Bernardo again. The transmission tower that will be closest to the proposed pole currently stands at 85 feet above the ground. That would be the last structure in that line before we get to the pole.
Thank you.
And Mr. Chair, this is Tom Johnson again. That's all we have at this point.
Okay, thank you. Okay, board, last questions? Then let's close the evidentiary hearing, move to board deliberations. We've had a conversation about at least two conditions. One, limiting the height to 100 feet of the tower, and a second one addressing vegetation. When someone makes a motion, if you would speak to those two conditions, and we may have to work to get the language for the second condition clarified. And I don't know how much we have to do now versus over time. I'm not sure, Catherine, but But anyway, let's discuss this further. I would like to point out that what we just learned, the power lines, it's a substation already existing. The power lines that are coming into it are 85 feet, the pole's 85 feet. So there's some fairly vertical element to the site already, plus a use that's utility-based use. So that is to take into consideration when we talk about a 100-foot utility tower going on a site. So I think we should offer that for the consideration, that it's, while a 100-foot tower, if it were a pristine site, might in fact be a challenge for neighbors. This is perhaps, in my view, an extension of existing utility capacity. So I'll offer that for what it's worth.
That was, I'd also like to follow up on that too. If there's anybody that can comment, as far as if there's a technical expert that can comment on the capacity of this particular telecommunication tower. You mentioned neighboring residents being able to receive better coverage. Is there anybody that can speak to that and what higher capacity this would offer?
Mr. Swink, I think what you can do is, Chair, you can agree to open the evidentiary hearing to allow the applicant to answer that specific question.
Okay, thank you. We will reopen the evidentiary hearings to get an answer if the applicant can provide one.
Thank you, Mr. Chair. This is Tom Johnson again. Again, we would rely on the statement from Verizon that says they have capacity issues in that area, and this tower is needed to offload that capacity in order to provide better coverage. And this location does rely on that statement. It's in the record.
Yeah. Okay, thank you. Other deliberation from the board? Okay, I would like to move that we special use permit VOA 0049-2020 with two conditions. Transmission tower, if that's the right term, be limited to 100, telecommunications tower, be limited to 100 feet in height. And secondly, that the applicant leave the existing vegetation in place to comply with the street and protect. Okay, I'm struggling here.
Okay, let's maybe say this, that they've requested relief from both the street and transitional protective yard. So that relief is granted upon the condition that, so maybe Mr. Butler's earlier statement that they won't be able to revert back to that if they can't provide the existing vegetation. So that they maintain the existing vegetation along, is it all existing vegetation or is it a specific area, Keegan?
I would defer to the applicant as to what vegetation they're looking to maintain.
Okay, so we'll ask them that in just a second, but say leave all existing vegetation in that area for as long as the property remains used for a telecommunications. Say that the specific existing vegetation to be maintained will be provided on a plan to staff at the time that they apply for the telecommunication tower. And I would ask Mr. Johnson to specify exactly the location. Well, again, the city, I mean, the board can, you don't have to get their consent to impose a condition. You can say all existing vegetation if you would like, but you can ask the applicant which vegetation specifically they were referring to.
Well, I would say all existing vegetation except what is necessary to construct the tower. I think we have to allow for that. And they did acknowledge that given if there's a loss of vegetation in the protective and street art area, they would comply, they would otherwise comply with those requirements. I think that's important. Because if there's a ice storm or as Mr. Cook was saying, some disease or something comes through and wipes a lot of it out, they've acknowledged a willingness to meet the street yard requirement. So I think that should be part of this condition.
And also with an allowance for the removal of any dead, unhealthy, and diseased trees. If
Right.
you could add that in.
Yes. Now, if we've got that, if we've captured that, I think we got the intent.
Ralph, no, okay, let's.
This is Tom Johnson again. Catherine, I'm fine with that, except for, we've got to construct an entry road in the site. But I mean, typically what we were doing is leaving existing vegetation to satisfy the street protective yard and transition protective yard. The street protective yard would be between the site. Protective yard would be to the adjoining property to the north.
Okay, then why don't we existing vegetation that's currently between the property in Leesville Road and the property and the adjacent property to the north, for so long as the property is used for a telecommunication tower use, except, where does it? They have the ability to remove any dead, unhealthy, and diseased trees. And in the event that they do not maintain the existing vegetation, they are required to provide the transitional and street protective yard as set forth in the UDO. Does that cover everything?
We would consent to that. That covers it from our perspective, Catherine. This is Tom Johnson, by the way.
Thank you. That's exactly what I meant to say. Thank you.
Mr. Clerk, did you get that?
Ms. Hoffman, I'll have to rely on you as to the exact wording because it does not make sense. I'm sorry.
Okay.
Okay.
Well, I guess let me ask the board. I mean, the condition says that they will maintain the existing vegetation that is currently located between the property and Leesville Road, as well as the property and the site adjoining the property to the north, with the exception of the ability to remove any trees that are dead, unhealthy, and diseased. The vegetation they'll be maintaining will be, if they fail to maintain that existing vegetation, then they will have to provide the street and transitional protective yards, and that the existing vegetation will have to be shown on a plan that is submitted with their, at the time they apply for the telecommunication tower. And maybe if we can unmute Justin Remetta and ask if that would be fine with the interview staff.
This is Justin Remetta. I think that would be fine. I would also just ask Mr. Johnson if you would consent to replacing any vegetation that is removed due to that other clause within 180 days.
I'm sorry, Justin. I was trying to make sure. So you want us to replace, if anything is diseased or dying, replace it in 180 days. That's fine. No problem.
This is Keegan McDonald. I just wanted to also comment, Catherine, that in that version you just read off, because the chair, I think, mentioned this, the ability to potentially remove trees during the construction of the tower. I'm not sure if that's specified in the condition as you stated, but it seems like that would be, or that was part of the original intent from the chair, but I'll defer to him. I just want to make sure that that's included if that's the intent.
It is. I think we have to allow for the fact that to construct this, they may have to extend a road or clear a path or clear a pod. So yes, we have to allow that. So just removal of any vegetation necessary to the construction of the tower.
Okay, so and one other thing I would add, Mr. Chair, is that you have the two conditions about the vegetation and the height limited to 100 feet, I believe. The other thing is I would just make sure to say that you are otherwise approving the request as requested, because they requested also a setback relief. So I don't know if you are approving that or not, but if that's part of your motion is to approve it as requested and accept as altered.
Yes, it was actually to approve what was requested with these two conditions. So yes, thank you for clarifying that. So I have put forth a motion with two conditions. I have a second.
Second.
Mr. Miles, a second. Thank you. Is there any further discussion? We have a motion and a second. We'll go to a roll call vote.
Okay, Chairman Swink.
I approve.
Thank you, Mr. Mile.
I approve.
Thank you, Mr. Coons.
Approve.
Thank you. Ms. Rudisell?
Approve.
Thank you, Mr. Sutton.
I would dissent on this.
All right.
Just to make sure, since we can't see, if you could state your name and then state your vote. Sorry.
Sorry, Justin Sutton, dissenting. Vote.
Thank you. That makes it 4-1.
Okay, thank you very much. Thank you, Mr. Johnson. Let us move along to evidentiary hearing case 3. This is the Old Town WEHL, excuse me, let me start again. Design adjustment A-16-20. The address 02221-2231 South New Hope Road, 4901-5125 Rock Quarry Road, Old Town WEHLP, OT Retail East Company LLC, and Lobro LLC property owners.
Okay, Mr. Chair, we have 4 people signed up to participate in this case. Again, when I call your name, please state your name and address and confirm your consent to proceed in the remote format. Jamie Swedler.
This is Jamie Schwedler at 301 Fayetteville Street. I do consent to the format, and my colleague Laura Good will be presenting today.
Okay, Ms. Schwedler, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank
And
you.
can you please state your consent to proceed? I'm not sure if I heard.
Yes, I do consent to proceed.
Laura Good.
Hi, Laura Good with Parker Poe. My business address is 301 Fayetteville Street, Suite 1400, Raleigh, North Carolina, and I do consent to proceeding in this virtual format.
And Ms. Good, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ryan Akers.
Hey, good afternoon. This is Ryan Akers at 2905 Meridian Parkway, Durham. I do consent to the online format.
Mr. Akers, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, and nothing but the truth?
Yes, I do.
Thank you.
And Eric Rifkin.
Good afternoon, Eric Rifkin at 5600 Street, Apex, North Carolina. I consent to proceeding with the virtual meeting format.
Mr. Rifkin, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I affirm.
Okay, thank you. Mr. McDonald.
Thank you very much. So the nature of request, whereas Old Town WEHLP OT Retail East Company LLC, Lobro LLC property owners request relief from the following roadway and streetscape improvements for Rock Quarry Road and South New Hope Road, Avenue 4-lane divided streets set forth in Section 846B of the Unified Development Ordinance to replace the required 7.5-foot bike lane with a 10-foot multi-use path. A 5-foot design adjustment to the required 38.5-foot section back of curb to back of curb that results in a back of curb to back of curb of 33 feet. A 5-foot design adjustment to the required 7.5-foot bike lane that results in a 2.5-foot curb and gutter width. And a 0 to 2-foot design adjustment to the required 2-foot maintenance strip resulting in a variable width maintenance strip in order to subdivide a 290.18 acre property zoned R10CU and CX5CU located at 0221-2231 South New Hope Road and 4901 and 5125 Rock Quarry Road. So as you can see from this image showing the zoning on the property, it's a rather large assemblage associated with a specific site permit review. This particular design adjustment is seeking relief to the streetscape and roadway improvements for those are again our Rock Quarry Road and South New Hope Road. If you could please advance 2 slides. Excuse me, go back 1 slide. Apologies about that, Eric. Thank you. So this is the cross-section that's being referenced in section 846B of the UDO. So this shows the required of curb width being for 1/2 of the roadway is 38 and a half feet. Also shown here in labeled as G is the required bike lane, which is 7.5 feet. And also the maintenance strip labeled as D, which is 2 feet. So what is really being requested here is a modification of this cross-section to allow for a off-street multi-use path to provide the primary pedestrian and cycling elements. And so that ultimate width will be 10 feet for the multi-use path. If you could advance to the next slide, Eric. So this image shows South New Hope Road, which at that inflection point heads north, and then Rock Quarry Road, located more to the south of the site. You can see the 2 cross sections. Apologies if they're not perfectly visible. But again, the intent here is to modify the multi-use path for use on these particular roadway sections. I will note that this is a design adjustment request. It's related to specific transportation requirements contained in Chapter 8 of the UDO. Daniel King is here with the transportation review team. I do not believe they have any specific comments on the application, but they are here to answer any technical questions. That concludes my commentary. Unless there are questions for me, I believe the applicant does have a presentation to provide as well.
Great, thank you very much. Any questions for Mr. McDonald? Okay, Ms. Schwadler, Ms. Good? Not sure which is presenting.
Hi, this is Laura Good with Parker Poe, and I will be presenting on behalf of the applicant. Thank you. If we could go to the next slide. Thank you, Chairman Swink and members of the board. This slide shows the project area, including the 6 properties with frontages along South New Hope Road and Rock Quarry Road that are the subject of the design adjustment request. And you can see there in dashed lines in blue and purple, the road frontages that this request impacts. If you could please go to the next slide. So this design adjustment is a request for relief from the street section requirements of section 8.4.6.b to install a 10-foot wide multi-use path instead of the required 7.5-foot bike lane along Rock Quarry Road and South New Hope Road along the project boundaries as shown in purple and blue respectively on this slide. Next slide, please. So this shows the required street section for South New Hope Road and Rock Quarry Road, which Keegan mentioned earlier. Both are Avenue 4-lane divided streets and require a 7.5-foot bike lane which includes a 2.5 foot wide space for curb and gutter. What we are requesting to do is simply remove 5 feet of the bike lane from the travel way, leaving 2.5 feet for curb and gutter, and relocate that 5-foot strip to the streetscape, which would increase the planting area by 1 foot and increase the sidewalk by 4 feet to result in a 10-foot wide multi-use path. So that would result, instead of a 6-foot sidewalk, you'd have a 10-foot multi-use path for both pedestrian and bikes as shown on here. Next slide, please. This slide shows the resulting adjustments that we are seeking as part of this request. So as Keegan mentioned, to reduce the 1/2 street section back of curb to back of curb by 5 feet. So the current requirement is 38 feet. We are requesting an adjustment down to 33 feet to account for that 5 feet of the bike lane that's being taken over to the streetscape. Also to reduce the bike lane by 5 feet from 7.5 feet to 2.5 feet. Again, the 2.5 feet remaining in the travel way for curb and gutter. Importantly here, the travel lane for vehicles will not be reduced. So it will have the same width for vehicle travel. And then finally, to allow for a variable width maintenance strip, a 0 to 2 foot reduction from the required 2 foot maintenance strip. Next slide, please. So this shows the resulting street section as a result of this request, including the 10-foot multi-use path. And this is just an enlargement from the exhibit that Keegan showed in his presentation. So it circles the resulting 10-foot multi-use path on the side in the streetscape. And it also shows the remaining 2.5 feet of the bike lane that will be, again, retained in the travel way for curb and gutter. Next slide, please. So this design adjustment will meet all of the required findings for a design adjustment. The first being that it meets the intent of Article 8.4. It is a street type appropriate for the use with design elements reflecting the character of the city, while it's still providing adequate travel lanes for vehicles, cyclists, and pedestrians. We will be enhancing the travel lanes for cyclists and pedestrians with the wider 10-foot wide multi-use lane, and will also provide greater separation from the travel lanes for cyclists and pedestrians. There will, instead of the bike lane being directly adjacent to travel lanes, it will be separated by the 7 feet wide planting strip within the streetscape area, which will improve safety. And finally, again, we will maintain the remaining street design elements. There will be no reduction in the vehicle travel lane width. Second, this design adjustment conforms with the comprehensive plan and adopted city plans. It will provide, the multi-use path will provide a means of travel and connection for cyclists and pedestrians, and it will support multiple policies. First being land use policy 4.5 for connectivity, which encourages new developments to provide pedestrian, bicycle, and vehicular connectivity and provide an alternate means of access along corridors, which this multi-use path will do. Next, this will support transportation policy 1.3 for multimodal transportation design to offer residents safe and attractive transportation options, including pedestrian walkways and bikeways, and encourage street patterns in newly developed areas, providing multimodal transportation for access to and circulation between developments, which again, this multi-use path will do. And finally, supports transportation policies 3.1, 3.2, and 3.4 for complete street implementation, integrating multiple users, and pedestrian-friendly road design, with a street design for multiple transportation modes that are safe and convenient for vehicles, cyclists, and pedestrians. For findings 3 through 6, in terms of congestion, maintenance responsibilities, design of the adjustment, and stormwater maintenance, I will be calling on Ryan Akers in a moment to speak to each of those and how this adjustment meets each of those findings. Skipping one or more of the following conditions must be present, and for this design adjustment, it is the condition of transitioning from a different street section. So this adjustment will create a more natural transition from Rock Quarry Road and South New Hope Road, as this multi-use path will provide separate areas for pedestrian and bikes outside of travel lanes. So again, here the point and the goal is to separate the bike lane from the travel lane. So as currently required by the UDO, that would have the vehicle travel lane directly adjacent to the bike lane. This will take the bike lane out and have a widened path within the streetscape that's, again, separated by 7 feet of plantings in that streetscape area for pedestrian and bike safety. So it will improve safety along these large, heavily traveled roadways. So at this engineer with McAdams to speak to those 4 other findings of facts as an expert and to be available to the board for questions as necessary.
Okay, can you all hear me?
Yes.
Okay, great. Good afternoon, Chairman Swank and members of the board. My name is Ryan Akers. I'm a licensed professional engineer in the state of North Carolina. I work for McAdams, located at 2905 Meridian Parkway in Durham. I've been an engineer for 16 years, and I have a master's degree in civil engineering from Cornell University.
Thanks, Ryan. Have you reviewed the proposed site plan for its compliance and with the requirements for a design adjustment?
Yes, McAdams did do the design and the plans, and I have reviewed them.
Great. Was there anything else you wanted to add from your education and experience?
Not at this time.
Great. At this time, I would request that the board, I would like to tender Ryan Akers as an expert witness in engineering.
Okay, we accept that on behalf of the board.
Thank you. Ryan, in your opinion, would this request, as to finding number 3, would this request significantly increase congestion or compromise safety?
No, it would not.
And can you expand on that a little bit, why it would not increase congestion or compromise safety?
Sure. Well, it's actually the opposite. Because we're separating vehicles and pedestrians, we're actually promoting a safer condition for folks away from vehicles that are traveling along a busy arterial, such as Rock Quarry and South New Hope.
Okay. And will the vehicle travel lanes be reduced?
No.
Great. Thank you. As to finding number 4, would this request create additional maintenance responsibilities for the city?
No, the multi-use path maintenance will be similar in scope and not more than required for what would otherwise be a 6-foot concrete sidewalk.
Thank you. As to finding number 5, was this design adjustment designed and certified by a professional engineer?
Yes, it was.
All right. And as to finding number 6, will the adjustment address stormwater collection and conveyance and not adversely impact stormwater collection?
Yes, it will. The adjustment will be served by the planned stormwater collection facility and conveyance required otherwise by the UDO for the purposes of this development and will not adversely impact the stormwater collection system.
Thanks, Ryan. If there are no other questions for Mr. Akers or for our team, we have nothing further at this time.
Okay, great. Thank you very much, Ms. Good. Board members, do you have any questions for the applicant team? Okay, Ms. McDonald, do you have any follow-up questions for the applicant?
I do not.
Okay, thank you. Is there anyone else here who wishes to speak in support of this request? Anyone else here wishing to speak in opposition of this request?
Mr. Spink, I'm sorry, this is the one transportation item. You might want to see if Daniel King has anything to add as well from staff.
Okay, thank you for that reminder. I wrote the note down and didn't see the note. Mr. King, is there anything you would like to add to this conversation for our benefit?
Thank you, Mr. Swink. Nothing specific to add. I will just note that as Ms. Schwedler and Mr. Akers indicated, this is actually just a reorientation of all of the individual elements of the street requirements. They're just putting them in slightly different locations, which actually has some positive effects in this particular case. So I'll just share that with you as just a reiteration of what they've already told you. But beyond that, I have nothing more.
Great. Thank you very much.
Chairman Swink, I'm
Yes.
sorry, this is Laura Good, if I may. I'm sorry to interrupt you, but I did want to also request that our application, presentation, and the staff case report be entered into the record at this time.
Great. Thank you, and we'll have to receive that. I was just had to ask if you had anything else to offer. So beyond that point, anything else you would offer?
Not at this time, thank you.
Okay, likewise, give staff one more opportunity.
I have nothing further to add at this time.
Okay, great. Board members, any further questions for either the applicant or staff? Hearing none, I will close the evidentiary hearing, move it to the board for deliberations and a motion.
This is Mr. Mile. I'd like to make a motion to approve.
Okay, we have a motion to approve. Is there a second?
John Kuntz, second.
Thank you, Mr. Mile. Mr. Kuntz, any further discussion from the board? All those in favor, we will have a roll call vote.
Thank you. Mr. Mile.
Approve.
Thank you. Mr. Kuntz.
Approve.
Thank you. Chairman Swink.
Approve.
Thank you. Ms. Rudisil.
Approve.
Thank you. Mr. Sutton.
Approve.
Thank you. Make 5.
Okay, thank you very much. We are just almost at 2 hours in. Let's take a 10-minute break and then come back and we'll move on to the next case. So 10 minutes to reconvene at 3 o'clock.
Thank you.
Welcome back. Let's move on to evidentiary hearing 4. This is a special use permit, BOA 0017-2020, 8100 Bellingham Circle. Kelly Ratliff is the tenant applicant.
Mr. Chair, there's 2 people signed up to participate in this case. Again, when I call your name, please state your name and address for the record and confirm your consent to proceed in the remote format. Kelly Ratliff.
Yes, my name is Kelly Ratliff. My address is 8100 Bellingham Circle, Raleigh, North Carolina, 27615. And yes, I give consent for the remote platform.
Okay, Ms. Ratliff, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
And Fred Crisp.
Yes, my name is Fred Crisp. I live at 6904 Tanbark Way, Raleigh, North Carolina, 27615. And I give consent to this virtual format.
Okay, Mr. Crisp, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Welcome, Mr. Hodge.
Thank you. So this is a request for a special use permit pursuant to section 6.7.3.E and 10.2.9 of the Unified Development Ordinance in order to operate a live-work business as an accessory to the principal residential use of the property. The specific live-work business in question here is for a dog grooming business, and it would be located within an existing detached house, zone residential 6, and as noted earlier, is at 8100 Bellingham Circle. There are 8 showings that the board needs to find in order to approve a special use permit. And then one of those showings specifically cross-references compliance with any use standards associated with the proposed use. And the live work, which is essentially a home occupation in which you have some limited number of clients coming to the premise. There are 14 standards associated with live work. The applicant's application that you can see in board docs has provided responses to both the 8 general showings as well as the standards for live work, of which there are 14. The first being that they secure a special use permit, which is what Ms. Ratliff is here seeking today. I would defer to the applicant to go over their information relative to the showings and standards for live work. There is one issue that would need clarifying from the applicant there as it relates to standards for live work. Number 14, the standard says 1 additional parking space is required for a live work unit. And that means in addition to the 2 spaces that would be required for a detached house. The applicant has indicated 2 spaces are available. I believe that is just kind of a wording situation in which they mean there are 2 additional spaces beyond the space that Ms. Ratliff would be occupying. So I do believe that that standard is being met with three parking spaces, but the specific wording of her response should receive some verbal clarification during her presentation. Other than that, staff has nothing else to say about this case unless you have questions of me at this time.
Great, thanks, Mr. Hodge. Do board members have questions for Mr. Hodge? Hearing none, let us move on to Ms. Ratliff. Welcome.
Yes, I'd like to start by thanking you for the opportunity to speak. I'm going to be representing myself. When the city showed up at my door, I was shocked to hear someone had actually made a complaint because I live in a dead-end court and I know all of my neighbors very well. I had spoken to them as well as my landlord, Fred Crisp, prior to grooming out of the house. None of them had a problem with it. I even groom actually several of their dogs. So the only thing I could think of was I had a sign that was sitting in front of the garage door. And the day you guys showed up to notify me, I removed it immediately. So it's completely out of sight. So now it looks like any other house on my street. So you can't even tell. And as far as my business goes, I give dogs haircuts. I start no earlier than 8 a.m. I finish no later than 1. And I do it in the house, so no dogs are outside or using the bathroom outside. They're just there for the haircut and leave. There's no daycare, no boarding, no stayovers. I groom them straight through, as well as no more than 2 customers are there at a time. And like you mentioned prior about the parking situation, yes, there's 2 spaces for people in the driveway if need be. They park there to drop off the dog, and they don't impede the road in any way or block anyone else's driveway. And I order things for the business about once every other month. These things would be limited to like shears, clipper blades, brushes. So these and a special use permit, which is why I'm doing all of this now, thanks to the complaint. I'm aware, and I'm trying to get caught up. So I hope I've covered everything in what I said.
Thank you. Thank you. I do have one question, just a clarification that Mr. Hodge made about parking, that there needs to be one additional space beyond the 2 that are required for the residential use. So, what are you saying you have available?
There's a total of 3, including my space.
Okay. Thank you. Just needed to be clear.
Yes.
Board members, that's okay. Board members, any questions for Ms. Ratliff?
Well, just to follow up, Mr. Chairman, so she says there's 3 parking spaces, 1 including hers. And so
Correct.
You're saying Eric indicated you needed 1 more beyond that. So you need 4. Is that correct or am I incorrect?
Mr. Hodge, my understanding was there would need to be 3 spaces. Is that? Mr. Hodge?
Eric, you're on mute.
I'm unmuting. Sorry about that. Yes, 3 spaces total. So she having a space and then 2 additional spaces for the clients satisfies that requirement.
Okay. Thank you, Mr. Butler.
And also, Mr. Chairman, so she indicated too that she works from 8 to 1 p.m. So is there language that says that's what's allowed for a live-work environment? Or can it go beyond the 1 p.m. or earlier?
I would, Eric, do you have an answer to what the code requires? If there's any restrictions?
The code does not specify hours of operation. The board could specify hours of operation if there were concerns with the proposed hours.
Okay.
This is primarily, she's doing it during the day, 8 till just a little after lunchtime, basically. So typically the board has in the past for live work have seen things between say 8 to 6 p.m. tends to be acceptable for most previous live work permits that we've seen. So her proposed hours are more constrained even than that.
Okay. Thank you, Mr. Chairman. Thank you, Eric.
Yes, sir. Thank you. Board members, other questions? Nope. Okay. Eric, do you have any follow-up questions for Ms. Ratliff?
I do not. Well, we might want to know if she proposes this. Is this 5 days a week, 7 days a week, 6 days a week? That's
5 days.
So Monday through Friday?
I do it Tuesday through Saturday.
Okay.
Okay, thank you. Any other questions, Eric or board members?
Nothing from staff.
Thank you. Okay, is there anyone else here who wishes to speak in support of this request?
Yes.
Identify yourself, please.
Am I unmuted?
We can hear you.
Okay, yes. I'm Fred Crisp, the landlord. And I just wanted to say that there is a parking pad that was added to the driveway. So the driveway can actually hold 3 or 4 cars for the driveway. Also, when this house came up for rent, I had some tenants in it in the past that weren't probably neighborly friendly. And so I made an effort this time to offer the neighbors a referral fee if they found me a tenant. So the neighbor did find me Kelly, and so she was kind of picked by her neighbors to be there. When the neighbors found that there was a zoning issue, they were really upset that they might lose Kelly there. So she's a really asset to the neighborhood. And I do believe her mom lives in the neighborhood, so I don't think she's going to do anything besides that, she is one of the best. She, her daughter, and her business are causing less wear and tear than the previous tenants that I've had. I have absolutely no problems with her being there. And she's been very upfront with me about the process that we're going through. I appreciate the opportunity for letting me speak. Thank you.
Thank you, Mr. Crisp. Just for my edification, Ms. Hill, he was acknowledged as a witness with the applicant. Perhaps we should have heard him then. I don't know that it matters, but in the future, should I have handled that differently?
No, that was fine.
Okay, thank you.
You're good, yep.
Okay, good enough. Is there anyone else who wishes to speak in support of this request? Anyone wish to speak in opposition of this request? Okay, then let us go back one more time, Ms. Ratliff. Anything else you would add for us?
No, that will be it. Thank you.
Okay, thank you. Staff, anything further?
No, thank you.
Board, last questions? We'll close the evidentiary hearing, move to the board for deliberations and a motion.
I'll make a motion to approve.
Ms. Rudisill, is a motion to approve. Is there a second?
Second.
Mr. Miles, second. Any further discussion? Move to a roll call vote.
Thank you, Mr. Chairman. Ms. Rudisill?
Approve.
Mr. Miles?
Approve.
Chairman Swink?
Approve.
Mr. Coons?
Approve.
Mr. Sutton?
Approve.
Thank you. That makes 5.
Thank you very much. Thank you, Ms. Ratliff. Okey-doke. Evidentiary hearing number 5, 1205 Martin Luther King Jr. Boulevard. This is a variance, BOA-0027-2020. North Carolina Nephrology Holdings LLC, Rock Quarry, was the property owner.
And Mr. Chair, you have 2 people signed up to participate in this case. Again, when I call your name, please state your name and address for the record and confirm your consent to proceed in the remote format. Isabel Maddox.
Good afternoon. My name is Isabel Maddox, P.O. Box 946, Raleigh 27602. I confirm my agreement to proceed in the remote format.
Ms. Maddox, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And Mark Phillips.
Yes, my name is Mark Phillips. We're the engineer of record for PAPS Design Group, address 107 Fayetteville Street, North Carolina, Raleigh 27601. Yes, I give consent to this virtual format.
Mr. Phillips, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Hodge? Are you muted again?
I keep getting muted. I promise you I'm not doing it myself. This is a request for a variance for relief for a wall or fence and landscape. 3.5.3 of the Unified Development Ordinance in order to permit an approximately 7,207 square foot general building on a 1.43 acre parcel, zoned OX3 parking limited. So OX is office mixed use. 3 is 3 stories, parking limited, and conditional use district located at 1205 Martin Luther King Jr. Boulevard. The adjacent parcel in question is actually this. Do you see the arrow on your screen?
Yes.
So it's this little triangular parcel here that's actually owned by the city of Raleigh. It has a residential 10 zoning on it and is otherwise vacant. The neighboring parcel has some split zoning and some commercial uses on that property. So therefore, that parcel does not trigger the neighborhood transitions. However, this small residual parcel that I believe is a remnant of when Martin Luther King Jr. Boulevard was widened or installed through the area. It was just some residual right-of-way and is a fairly small and undevelopable piece of property in and of itself, given its small nature. The applicant will go into more detail about that, but that's the parcel where the ordinance would otherwise call for a fence and landscaping to transition from their proposed medical use. I believe it's a dialysis clinic on this site. And so that property really, for all intents and purposes, functions sort of like just extra right-of-way in that vicinity. It's not right-of-way, it's a separate parcel, but really in and of itself has very little utility, particularly for a residential use on that parcel, given its odd size and unusual configuration.
Okay. Anything else? Mr. Hodge, you're muted again.
The large parcel to the northeast has some commercial use. As you can see, there's some automotive storage and whatnot going on with that property. There are, I believe, a smattering of commercial uses on that property. There, again, we're focused essentially here where I'm going over with the cursor, where they're seeking relief from the fencing and or walling between that parcel and the subject property and the associated landscaping that would otherwise be called for. Because again, the code assumes that that parcel would be suitable for residential use in the future. So that's why they're here seeking relief, because they do not believe that that would be the case.
Okay. Anything else?
That's all I have.
Okay, great. Any questions for Mr. Hodge?
Eric, this is Marvin. Is there enough room there to build a residential home on that piece that you just pointed out with the arrow?
It would be extremely challenging, and I believe the attorney in the case can give you their rationale for why they believe that to be the case. But it is a very, very small piece. I don't recall the exact acreage. I can look that up of that property, but it is very small. Hold on just one moment.
Windows 7.
Correct. It is 0.07 of an acre. So it's not even a tenth of an acre and has an unusual configuration and may well even require, residential uses would not trigger right-of-way dedication, but it would be challenging, I believe, given that configuration and that small acreage to successfully build there. And then getting a driveway onto the site off of Martin Luther King Boulevard, I think would be an additional challenge as well. And again, the city owns the property.
Okay, thank you, sir.
Thank you. Any other board questions? Okay, Ms. Maddox, welcome.
Thank you, and good afternoon again. My name is Isabel Maddox. I'm here on behalf of NC Nephrology, LLC, the owner of the property, developer of a kidney dialysis center in Southeast Raleigh. Here today with Mark Phillips of PAPS Design, our engineer and landscape architecture firm. We do want to submit our application exhibits for the record. We're requesting what I believe is a very small variance to a very technical requirement today. Normally, I wouldn't say that a variance to a neighborhood transition would be a small thing. It typically requires a transition yard with a depth of 50 feet when mixed-use development abuts residential. And there are zones A, B, and C required with specifics as to each one. In this case, however, the requirement arises from the fact that the subject property abuts a very minuscule remnant of property owned by the city, which was left on the north side of MLK following the construction of MLK. Eric, if you can scroll to the zoning map, which shows the parcels a little bit better. Yeah, there you go. You can see on the south side of MLK, there are several parcels, and those are owned by the city. MLK Memorial is actually there on the south side of the boulevard at that location. So this was a little remnant that just stayed on the north side. It's only 0.07 acres, and because of its small and irregular dimensions, it's unlikely to ever be developed. In this case, and Eric, if you'll go to our site plan, we still plan to and agree to on our site plan commit to the entire 50 feet of separation. The thing we need relief from is the specifics of Zone A. Zone A requires specific landscaping and a fence or a wall. And there is the green area in this site plan is City of Raleigh sewer easement. And there's a current sewer easement, there's a current sewer line that's 20 feet wide. The city's requiring it be expanded to 30 feet and will not generally allow a fence or a wall to be placed within that easement. So we're maintaining the distance from that parcel, but not the exact plantings, fence, and wall. The strict application would mean that we couldn't start our 50 feet of separation until the other side of the sewer easement. And we run into problems there because we have other things we need to do on this site to comply with other city requirements. We have to have, we have to have a stormwater facility. We have to have cross access, which is the orange area that goes along the rear of our site. There's also a zoning condition on the property that precludes the placement of any vehicular surface area between the building and the road, requiring the building to be placed close to MLK Boulevard to accommodate parking in the rear. And the city has required 2 access points, one on MLK, one on Vardaman Street. They dictate the placement of the building. So it's a fairly tight site, and we have to put the building where it works with the access points and the zoning condition. The hardship did not result from any actions taken by the applicant. The odd little remnant has been in existence for many years. We do believe that this request, and let me go through this. So in the transition yard, you have zones A, B, and C. A, you have landscaping and a fence feet. So we're maintaining the fence or wall and landscaping. B requires another, depending on how big zone A is, you go another 10 or 20 feet. And then zone C takes you up to the total 50. So we have all that distance there, and we'll actually put a line of plantings. And Eric, can you put our site plan up that we presented to you last week? Well, that doesn't really show our landscaping. There will be a row of plantings that we propose that will be 9 feet, a 9-foot row of plantings after you go after zone B or after zone A and part of B. There will be a 9-foot row of plantings that between the retention pond that you see in gray there. So you will still get the 50-foot distance. You'll still get plantings. You won't get the fence or the wall. We feel like any impacts from this variance are mitigated by the fact that you still have the distance, you still have the plantings, We don't think this property will ever be developed. The lot size is smaller than is required for even a single family lot in R10. Now, you could get a building permit for one single family house here, but again, the size of this lot makes it very unlikely, and it's on a very busy street. So even if you did have a house there, you have the spacing, you have the landscaping, you don't have it exactly the way the code calls it out. And we do believe public benefits are served in that this is a dialysis facility. We have a certificate of need for this dialysis center. To get a certificate of need, you have to show a geographical need. This will allow people in this neighborhood to come to this dialysis center for their dialysis needs, as opposed to having to drive a lot farther away, which, if you have to come every day or several times a week, it's a big help to have that close by. And the fact that we can get a certificate of need here shows you that, there is need here. So we do believe that's a major benefit to this part of town to serve the many patients that need dialysis. And we think that the impacts of this variance will be very minimal, and we don't think there's likely to even be any residential development in that small triangle piece of property. So with that, we'll conclude. I'm available for questions, as is Mark Phillips, our landscape architect. So
Great. Thank you very much, Ms. Maddox. Board members, any questions? Okay. Mr. Hodge, do you have any questions for the applicant?
I do not.
Wish to speak in support of this request? Anyone wishing to speak in opposition of this request? Okay, Ms. Maddox, I'll give you another chance to offer us anything else you have.
I think I've said it all.
Very good. Likewise, Mr. Hodge.
Nothing else from me.
Board members, last chance for questions. Okay, we'll close the evidentiary hearing, move to the board for deliberations and a motion. Hearing none, I will move approval.
Second.
I'm sorry, who was the second? Mr. Coons?
Yes, sir.
Any further discussion? Go to a roll call vote. Years and years of practice. I can't quite get it right.
Someday.
Continue on your toes, yeah.
All righty. Mr. Chairman Swank.
Thanks to pandemic.
Calling the roll, Chairman Swank.
Approve.
Thank you. Mr. Coates.
Approve.
Thank you. Mr. Mile.
Approve.
Thank you, Ms. Rudisil.
Approve.
Thank you, Mr. Sutton.
Approved.
Thank you. That makes 5.
Excellent. Thank you very much. Thank you, Ms. Maddox. Moving along, evidentiary hearing number 6. This is a variance, POA-0030-2020. This is at 2101 2051 Century Drive. It's Carolina Hotel Investors, Crabtree LLC, and CHI Crabtree 2 LLC, property owners.
Okay, Mr. Swink, you have 4 people signed up to participate in this case. When I call your name, please state your name and address for the record and confirm your consent to proceed in the remote format. Collier Marsh.
My name is Collier Marsh at 301 Fayetteville Street, and I consent to this online format.
Mr. Marsh, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, the next person, Mr. Chair, is Russell Ranson. He, Collier might be able to explain this, but he is signed up to provide the same testimony that another person for the applicant will be presenting today. He has sent us an email confirming his consent to this remote platform and stating that he will not be in the meeting today. If you're comfortable proceeding with that, we have that for the record, his consent. And I'll let Collier explain. I believe the next person, Neil, that I'm about to call is his replacement, so to speak.
That's fine. If we have his approval, which we do, then we can move on.
Okay. So Neil Capadia,
Yes.
can you please state your
This is Neil
address?
Capadia. Sure. This is Neil Capadia. My address is 3800 Pomfret Lane, Charlotte, North Carolina. And I consent to the virtual format that we're doing for this hearing.
Okay, Mr. Capadia, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, and Andy, I don't want to mispronounce your last name, so I'll let you state it.
Yes, this is Andy Padiak with McAdams, and my address is 1 Glenwood Avenue in Raleigh, and I also consent to this virtual format.
Okay, Mr. Padiak, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Mr. Adams.
So this property has been before the board previous, but code requirements and have begun the permitting process for another hotel on one of these sites. The parcel to the east where it says Shad 2, I believe is where the proposed additional hotel. The other building on the property is an existing hotel. It's been various brands over the years, but is at the interchange of Glenwood Avenue and I-440. And to the north of Century Drive there, you have Crabtree Creek coming from the west, from the Crabtree Mall area, flowing north of the site, and an existing solar array on those parcels to the east and northeast of the site. Today, they're seeking relief from the for variances for complete relief from the vehicular parking lot tree planting requirements set forth in section 717F of the Unified Development Ordinance, as well as the street tree planting requirements set forth in UDO sections 8.4.5.A and 8.5.2.G in order to permit the new hotel on the property, which totals 4.5 acres and has Office Park 12 and Shad 2 zoning on it. And these parcels are located at 2101 and 2051 Century Drive. The reason there are two parcels in the request is there's an associated subdivision here that is triggering some of this compliance as well. So it's kind of a two-part situation. It's not all triggered solely by the hotel construction, but has some relevance to the subdivision that would trigger street tree installation on all parcels associated with the subdivision, even the piece that already is developed with a hotel. As you can see in the applicant's information, this site is a former landfill, and as such, there are some environmental concerns with additional disturbance of the substrata there with planting trees, with additional trees, and removing the encapsulated fill material that's on the site. And they have some documentation from the state to that effect. As such, staff really has no additional comment or any commentary related to the nature of this request, unless you have any other questions of us at this time. Here's the aerial. Sorry for not moving forward with that earlier. Those bars there to the right of the site and to the north, that's the solar array that's located on the adjacent property. And we're talking about street trees specifically along Century Drive, and then any parking lot trees that would be associated with the proposed hotel. This gray box here is where the new proposed building would be, And so they had a plan that was essentially, kind of in review. And they had originally shown those trees to be planted along Century Drive as well as in the parking lot when this case came forward to the board in the past. But through subsequent permitting, that's when it was discovered that there were some concerns on the part of the state with additional disturbance of that landfill underneath the site. So with that, that would conclude my presentation unless you have any other questions of me.
Thank you, Mr. Hodge. I do have one, and maybe this will be one best answered by the applicant. So I'll give you both the opportunity. But there is a proposal for a new building to be built, which I assume would require some site disturbance. That has been approved by the state. Or do you know?
I would let the applicant speak to that. I believe the state is just trying to limit the amount of disturbance associated with this new construction.
Okay.
I do believe there would be.
That's good. I'll reserve that question for the applicant.
Okay.
Board members, any other questions for Mr. Hodge?
I just overall, for tree planting requirements prohibited by the North Carolina Department of Environmental Quality, is that site specific here, or is that overall, former waste management land? Do you know?
I'm assuming that the state is doing it based on their policies, which they apply project by project. I don't know that there's a blanket prohibition.
Yeah.
Completely.
It's a great reason to plant them, but obviously there's reasons beyond which I know of why you can't, whether that's site specific or overall. And this is not a question for the applicant. I'm just curious is my overall question.
Well, I mean, there are remediation practices that environmental professionals, which I'm not one, but perhaps one of their experts on the applicant's team can speak to. Sometimes things are, it's better to let sleeping dogs lie, if you will,
right. rather
than to disturb and, encapsulated containment.
Yeah, makes me wonder about my meandering that greenway down there, though. Okay, I'll give it. Thank you.
The greenway's on the other side, I think, of the creek here.
Okay, let's move on to Mr. Marsh.
Okay. Can you all hear me okay?
Yes, sir.
Okay. Good afternoon, Chairman Swink and members of the board. Again, I'm Collier Marsh with Parker Poe at 301 Fayetteville Street, and we are the attorneys for the property owners here, Carolina Hotel Investors Crabtree LLC and CHI Crabtree 2 LLC. Eric, if you don't mind turning to my slides. And at this time, I'd ask that our application, our presentation, case report, and all of our supporting materials be accepted into the record.
Thank you.
Okay. Next slide, please. So we've organized this presentation. I'll speak to the basic request, and then I'm going to hand it over to Andy Padiak with McAdams. And I think that we will address the questions that have already come up, but to the extent we don't, we're certainly going to be available to answer those questions at the end. But this is the yellow, two parcels, 2101 Century Drive on the left-hand side and 2501 Century Drive on the right-hand side. Come before the board back in April of 2018 for a variance that permitted the subdivision of the site. In essence, there needed to be a reduction in the permitted lot size for the parcel to the right, as well as a permitted parking lot reduction. So that was April of 2018. We actually had to get an extension of that variance in April of 2019. Unfortunately, in discussions with staff, we don't need to extend that original variance again. So our request is a bit more narrow than we had originally thought. But this project has been through a lot of review, and we had actually reached the point of what we believe to be approved in final site plans before this final issue came up. And so we're hoping to get your approval for our request so that we can finally proceed to construction on the site. So what we're seeking relief from are the street tree planting requirements of UDO section 8.4.5A and 8.5.2G. And that's to seek relief from the requirement to plant trees along Century Drive. So you see Century Drive in the black letters there as part of the subdivision, and then as part of the development of the site, those requirements are triggered to plant trees along Century Drive. Then the second request that we're seeking is relief from the parking lot tree planting requirements of UDO 7.1.7F. And we're seeking relief from the requirement to plant trees on that property to the right, that parcel to the right upon the final development. If you could go to the next slide. So the reason for our request is pretty straightforward. We actually planned to plant all of the required trees and went through the approvals process with the intention of planting all of the trees along Century Drive and on the parcel to the right. But we were subsequently notified by the North Carolina Department of Environmental Quality that we would not be permitted to plant any trees on the site. Because the site is a former landfill used by the city of Raleigh from 1959 to 1968, before there are certain regulations in place. And so the current guidelines prohibit the planting of trees. But I'm going to hand this over to Andy Padiak with McAdams, who was involved in the site planning process. Bit details as to how that process yourself and explain to the board what happened here.
Well, thank you, Collier. This is Andy Padiak, and again, I'm a civil engineer and a group manager here at McAdams, and our address here is 1 Glenwood Avenue in downtown Raleigh. The slide shown is the original approved site plan, which was approved on October 30th of 2019, so last fall. And as you can see on the approved site plan, we intended to plant all of the required street and parking lot trees. And if you could advance to the next slide, please. So after approval of the site plan on April 20th, so the site plan was approved last fall, so on then back to the spring on April 20th, the North Carolina Department of Environmental Quality Division of Waste Management notified us that trees are not permitted to be planted on the site. So if you could advance one more slide, please. So this, so the trees were not permitted to be planted because the site was used as a City of Raleigh landfill from 1959 to 1968. So the landfill runs beneath both parcels and also beneath Century Drive. So DEQ notified us that its land use restrictions for pre-regulatory landfills prohibit the planting of trees on the landfill footprint because not only can they penetrate and compromise the cover soils above the landfill, but if they ever fall over, the root ball will expose people to the landfill below. So DEQ's goal is to not expose or disturb the landfill in any way. So DEQ's decision was based on the DEQ report on pre-regulatory landfill vegetative cover, which is attached to our application materials. That report lists all permitted plants on pre-regulatory landfill sites and simply does not include trees. So we did work with DEQ to try and find a way to include trees on the site. So we supported our environmental consultant, McAdams supported our environmental consultant to have several discussions related to root ball depth of trees proposed as compared to the depth of the top of the landfill itself. So basically we had a number of conversations and discussions, and we provided evidence of different types of different types of trees and which ones have shallower root balls than others and such, trying to convince them of any kind of City of Raleigh allowed tree that might check the box for their landfill requirements. And long story short is DEQ will not support planting of trees of any sort on top of the landfill. So ultimately, we were left in a position where we had approved site plans, and then learning 6 months later after that, the DEQ would not support the planting of trees. So we did intend to plant all of the trees as required by the UDO, and we found ourselves in this situation before you today. So. Oh, sorry, I didn't need to do that. So as a result of DEQ's determination, we show the modified site plan, which removes the trees that were not permitted by DEQ. Yes, thank you for taking the slide back one. So at this time, I'll turn it back over to Collier Marsh at Parker Poe for his conclusion.
And if you could advance to the next slide. All right, so I just wanted to recap the factual scenario here and show how the variance factors apply. Certainly there's an unnecessary hardship. The property owners here are willing to provide trees. We had plans to provide those trees. We were told by the DEQ we were not allowed to plant them. We then went back and forth with the DEQ for quite a while, trying to find a way to plant trees and try to find a solution, and the answer was simply no. So compliance was prohibited, and as a result, without relief, there'd really be no opportunity to continue with this development. The hardship does result from conditions peculiar to this property. It results from the City of Raleigh's use of the site as a landfill from 1959 to 1968, a pre-regulatory landfill, and so the conditions that have kicked in based on that status of its former use are what prohibit compliance. And an assessment that was done of the property identified waste throughout the site to be developed, as well as all along Century Drive. So at any spot where we had tried to plant a tree, we're prohibited. Again, the hardship didn't result from actions taken by the applicant. It's just because of the former use as a landfill. And our request is consistent with the spirit, purpose, and intent of the ordinance. What we have here is a conflict between the UDO and DEQ regulations. We pushed for relief from the DEQ regulations first and hit a dead end there where there's no relief to be granted. So we've come to the Board of Adjustment to help resolve this conflict. And then just circling back to the one question about how can a building be permitted on the site, but no trees? And the answer is, one, there's remediation efforts that happen when the building's constructed. But two, I think the concern that Andy highlighted was if a tree falls, folks are then exposed to that waste because the roots will have penetrated the cover soils. There's not a similar risk of the hotel following, so we were able to get approval of the construction of the hotel, but not of trees. So with that, happy to answer any questions that the board may have.
Okay, thank you, Mr. Marsh. Mr. Padiak, I do have a question. So Chairman Swink again. Does the footprint of the landfill extend throughout your property 100%? Specifically, is there any area to the west towards Crabtree Creek that is not part of the landfill footprint?
So the notice that we were provided, it runs all along Century Drive and all along the right-hand side, I guess the eastern property to be developed, which are the two locations that we're seeking relief.
So well, again, I'm trying to clarify, is there a chance to the western edge of your property on Century Drive, is there an opportunity for street trees anywhere along Century Drive, or is that all part of the landfill footprint?
And if you could go back to, Eric, if you could go back maybe one slide, forward one slide. The notice we were provided was that they wouldn't be permitted at all along Century Drive. Does that answer your question?
I'm sorry, I was reading no trees are permitted on the landfill footprint, is what I'm reading.
So, and the footprint was beneath Century Drive in its entirety, as well as the parking lot, the property where we're seeking the parking lot requirements. Yes.
Okay, thank you. I'm just trying to clarify that, because if there's any chance for even 2 street trees, it's better than none. But if it extends the whole area, then I understand. I just wanted to be clear. Go ahead.
The trees on the western property will remain, so we won't be taking down any trees. Those were planted before these new regulations came in place. So there are trees on the existing hotel site before the new regulations were put in place, so that some trees will remain.
Okay. Secondly, Mr. Padiak, I know it is not a good solution. Is there any thought given to, or maybe it was ruled as not possible, any kind of raised trees, but small trees that might be planted in boxes? Therefore, there would be no roots extending into the ground?
We did consider that, and we did talk through it. And just for the longevity of planting a tree that meets the city requirements for that size tree, putting it in an elevated box would radically stifle the growth of the roots and such. So it just wouldn't look nice, and it definitely wouldn't perform. The tree wouldn't, survive for its normal lifespan under those types of restrained conditions.
Well, I agree with you. I just wondered if you had considered it. So good to know you at least thought about it.
We did, and we even considered furthermore to, what if we had if the site were higher and we had more cover between the landfill and the tree, but you can't fill in the floodplain either, so that was a restraint.
Well, yeah, I understand that. Thank you. Board members, any other questions for the applicant? Okay, Mr. Hodge, do you have any questions based on the applicant's presentation?
I do not.
Okay, thank you. Other participants, anyone here wishing to speak in support of this request? Anyone wishing to speak in opposition? Okay, we'll bring it back to the applicant. Mr. Marsh, any further information from you?
Nothing further. I will. North of the site is a solar farm, so perhaps they'd be relieved that they're not being trees aren't being planted there. Our client certainly would prefer to have trees if they could.
Yeah, thanks. Again, Mr. Hodge, one last chance for you.
Nothing else.
Okay, and board members, one last chance for you. Okay, let us close the evidentiary hearing, move to the board deliberations. I'll entertain a motion. Let me just say right up front, first, I thank you for trying to figure out a way to do this. We all know how important trees are, street trees, parking lot trees are in our area. Thank you for making the effort to see if it was at all possible. I'm sorry that it isn't, but I certainly appreciate your due diligence in that regard. Entertain a motion. Mr. Coons?
Motion to approve. It is what it is.
We have a motion to approve. Is there a second?
Second.
Mr. Mile, thank you for your second. We have a motion and a second. Any further discussion? Okay, we'll go to roll call vote.
Thank you. Mr. Coons?
Approve.
Thank you, Mr. Mile.
Approve.
Chairman Swank?
Approve.
Thank you, Ms. Rudisill? Ms. Rudisill? Ms. Rudisill, wave your hand because I couldn't hear you. Ms. Rudisill? I don't think she can hear us. Ms. Rudisill, are you saying yes? Wave your hand if it is yes.
Is she on mute or?
I don't know.
She's on mute.
She's not showing on mute.
She seems to be disconnected at this time.
Okay, so under this.
There she is.
Can you hear me?
We see her, but I don't know if she can see us.
Okay, under the new session law, a member has to be able to be heard in order to vote. So what we can do is try to get her in, or alternatively, we can see if an alternate can vote. And I'm pulling out my sheet to see who could vote in her place. So it would be either, it would be Mr. Kenny, because Mr. Rainey is not in.
So it would be Mr. Kenny in this case.
Right, and I'm not seeing him. Oh, there you are. Okay. Mr. Swink, how would you like to proceed?
Let's proceed with the alternate. You see if Mr. Kenny will weigh in.
Let me try one more time on Ms. Rudisil, please. Ms. Rudisil, can you hear us? Are you by any chance muted? She can see, but she cannot speak. Okay. In that case, we'll go ahead and call Mr. Sutton. You're up for your vote, please.
Yes, approved.
Thank you. And then finally, Mr. Kenny.
Approved.
Thank you. And we'll make 5.
Okay, thank you very much. Apologize for the technical difficulties there. That happens.
That's why we have alternates.
Yes, exactly. Let us move along to our last case for today, evidentiary hearing number 7. This is a variance, BOA-0046. Passage Home Incorporated and BB Redevelopment LLC property owners. And we have a host of addresses here, 1217, 1205, and 1201 Sawyer Road, and 1200, 1204, 1208, 1212, 1216, 1220, 1224, 1228, 1232, 1236, 1240, 1244, 1248, 1221, 1213, 1209, 1205, and 1201 Angelus Drive.
All right, Mr. Swink, you have 5 people signed up to participate in this case. When I call your name, please state your name, address, and confirm your consent to proceed in the remote format. Michael Birch.
Hello, it's Michael Birch with Longleaf Law Partners, 4509 Creedmoor Road, Suite 302, Raleigh 27612, and I consent to the remote meeting platform.
Mr. Birch, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, Tim Messenger.
Good afternoon. It's Tim Grissinger.
Hey, Tim, can you please give us your address and confirm your consent to proceed in the remote format? And it looks like Tim is on mute. Or
Can you guys hear me?
yes, there you go.
Sorry about that. Good afternoon. It's Tim Grissinger at Tim's Group. 5410 Trinity Road, Suite 102, Raleigh 27607. Give consent to this format.
Okay, Mr. Grissinger, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I did.
Thank you.
Jim Chandler.
Yes, Jim Chandler here with Timmons Group. The address is the same, 5410 Trinity Road, Suite 102, Raleigh, North Carolina, 27607, and I consent to remote meeting platform.
Mr. Chandler, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Kathy Connors.
Yes, this is Kathy Connors. I'm at 106 Muirwood Drive, North Carolina, 37513, and I consent to the
That's Santa Claus?
Sorry.
I might look like Santa with this beard, but it wasn't me.
Okay, Mr. Clerk, were you able to pick up her address?
No, I was not, because of all the intense feedback. I got her name, but not the address.
Okay, Kathy, we'll try unmuting you and see if we can do that again. And if not, Mike.
Sure. This is Kathy Connors, and I'm at 106 Muirwood Drive, North Carolina, 27513, and I consent to the virtual meeting platform.
I'm afraid the feedback is on her line.
Yeah, let's just really quickly so we can hear. I was able to hear her confirm her consent. I'm not sure if you could hear her address. Michael, do you want to try calling her, or Laz? Is there a way that you can call her into the meeting?
Yeah, I'll try to get a phone number for her. Give me a sec.
Yeah, I did hear her confirm the consent. I couldn't get the address.
Yes, I did too.
It sounded like 106 Muir Woods Drive in Cary. That's what it sounded like to me.
Okay, let's go ahead and do our last participant, and then Michael Birch, I'll ask how you want to proceed.
I need to swear her in. Are we going to do that now or hold?
Well, I have her consent for the remote meeting platform, and so what I was going to ask Michael is if he intends to use her for witness testimony, and if he does, then we will need to reaffirm her oath.
Thank you.
Okay, Wayne Jones.
Wayne Jones, 2005 Beach in the Circle, and I consent to this format, and that's in Raleigh.
Hey, Mr. Jones, do you swear or affirm that the testimony you will provide in this evidentiary hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, and Michael, what do you, is Kathy intending to present evidence for your case? How would you like to proceed? You might need to unmute Michael Birch, Laz. There we go.
Yep, I'm fine proceeding as is. I wasn't necessarily counting on her as a witness.
Okay, well, and if you can get Kathy back on the line during your hearing, that would be great. If we just need to make sure if she is going to give testimony that we reaffirm her oath. But I have her consent. I could hear for that. So, Mr. Chair, if you're ready to proceed, it's
okay. Yes, thank you very much, Mr. Hott. Once again.
Okay, so this is a request for a variance offering complete relief from the 2-foot minimum ground floor elevation standards set forth in section 1.5.7.b and 2.2.4.f1 of the Unified Development Ordinance in order to permit a 7-building apartment complex built on this assemblage of property spanning 6.25 acres zoned residential mixed use 3, which happens to be located essentially at the southeast corner of the intersection of Bragg Street and Garner Road. The addresses include 1217, 1205, and 1201 Sawyer Road, and 1200, 1204, 1208, 1212, 1216, 1220, 1224, 1228, 1232, 1236, 1240, 1244, 1221, 1213, 1209, 1205, and lastly 1201 Angelus Drive. Private street, north-south, running through here, essentially functions like a private drive or a parking lot for the development that was out on the site previously. So that's, for those of you that are wondering where Angelus Drive is, it's there, an internal street to the development. This is again just showing the parcel with some older multifamily units on the site that are proposed for redevelopment by a 7-building apartment complex. For apartment building types, that their minimum ground floor elevation is supposed to be 2 feet above the average curb level of the adjacent streets. The board has seen numerous requests for relief from this requirement over the years, where sites have varying topography relative to the elevation of the roadways adjacent thereto, and as well as some potential ADA issues where buildings are being elevated, where it's challenging to provide that additional height for the ground floor. And so the applicants are seeking relief from that requirement. I would note the city is considering, it has not moved forward, but there is a consideration for removing that requirement, or at least modifying it absent some frontage requirements because over the years since the UDO has been adopted, the city has received quite a few requests for relief, particularly for apartment buildings from this code consideration. And so staff is aware that sometimes it's a bit of a challenge. And so we do not have any opposition to the proposed request.
Thank you very
This
much.
is the site plan, again, showing the layout of the buildings on the site. And again, buildings of that size, making sure that all finished floors are 2 feet above the varying average street grade or curb grade elevations can be quite challenging on a site, particularly one of a larger size, to get everything graded such that it works out that way. And as you can see, there are some buildings where they are internal to the site as well. And so there are competing concerns with access from parking areas to buildings versus where those buildings sit, the ground floor, relative to the curb around the perimeter of the site. And that is what the applicants are here to seek relief from. Unless you have any other questions, that would conclude my presentation.
Okay, thank you very much. Any board member questions for Mr. Hodge? Okay, let's move along to Mr. Birch.
Great. Good afternoon. Again, this is Michael Birch with Longleaf Law Partners. And I have with me today Kathy Connors with Solstice Partners, who is the developer of this project, which is an affordable housing project. We also have Jim Chandler and Tim Grissinger, engineers with Timmons, and then Mr. Wayne Jones, architect with Jones Architecture. This time I'd ask that our application and presentation materials be accepted into evidence.
Okay.
Reiterate, our request is for complete relief to UDO section 2.2.4 F1 in order to permit apartment buildings that are less than 2 feet above the average curb level. And as we'll show and kind of walk through the grades, the existing topography of the site along the existing streets, as well as the requirement to extend Sawyer through the site from McMacken to Bragg Street. Creates those difficulties, as well as because this is a project funded by the Low Housing Income Tax Credit Program, there are funding restrictions that bring with it enhanced ADA accessibility requirements that, again, just cause further complications complying with this requirement. As a little bit of background, these properties are the site of the old Brown Birch affordable housing community that was developed by John Winters back in the early to mid 80s. Consists of about 74 units over those 21 parcels, largely in 4-unit buildings. There's one 6-unit building. Although initially developed as one project, these lots were divided up and then sold to individual owners, many different owners over the years, and many of these structures have fallen into disrepair. Passage Home, which is a group that you all may know, is focused on kind of breaking the cycle of poverty and creating kind of generational self-sufficiency by helping families achieve housing and income security. They have focused and spent over 15 years buying up these 21 parcels from many different owners in order to facilitate redevelopment of this site. For what is being proposed now, 200 affordable units that are affordable to those earning between 40% to 70% AMI. And again, this is located in the South Park area, less than 1 mile from downtown. And as y'all are familiar, given the gentrification experienced in this area, particularly recently, this type of housing is even more important than it was 15 years ago when Passage Home started down this path. In addition to the LIHTC funding, Wake County and City of Raleigh are also funding partners in this project. So if you could go to the next slide, this is the site plan. So on the top of the page, so it's a kind of turned about 90 degrees clockwise. So on the top of the page, you have Garner Road. Bragg Street is on the right-hand side, and Mackin is on the left-hand side. And then you can see the extension of Sawyer Road from McMacken to Bragg there towards the bottom of the page, north of those two buildings. So just to help you understand the grades that are occurring on this site. So along Garner Road from McMacken to Bragg, you've got about 4 feet of grade change, so not too bad. But as you come down McMacken from Garner Road to Sawyer Road, you've got about 11 to 12 feet of grade change. Garner and McMacken, that intersection being higher, about, call it 281 down to where Sawyer is at about elevation 270. On the other side there, Bragg, you have approximately about 30 feet of fall from Garner Road at about 285 at that location to Sawyer, which is about 255 at that location. And then along Sawyer Road itself, currently it's that kind of cul-de-sac that goes into the site, but the city regulations require the extension of that street. And there's about a 15-foot grade change from McMacken at about 270 down to Bragg at elevation 255. So again, dealing with a significant amount of grade change around the existing streets of the site, as well as the street that we had to install through the site. Also note, just along Garner Road, because the regulation is relative to the curb level, the curb in Garner Road is about 55 feet from the closest point at which these buildings could be located. About 30 to 35 feet of that is within the right-of-way. It's just a kind of an oversized right-of-way relative to the curb location in this segment. And then we also have a 20-foot stormwater easement required by the city on the backside of that property line along Garner Road. But our buildings are pushed as close to Garner as we can. But again, 55 feet back, and there's a significant amount of grade change that occurs within that area. Just kind of the variance request is for all of the buildings, but the problems really are for 5 of the buildings. Starting with the building up at the corner of McMacken and Garner, building identified as building number 3, that's about 5 feet below the curb level. So again, 7 feet below what the city would require. The building immediately to the east at Garner and Bragg is about 12 feet below the average curb level. So again, 14 feet different than what the city's regulations would require.
I think that's to the north, Michael.
Yeah, sorry, sorry, I'm looking.
This slide north is to the right.
Rotated, yep. No, I apologize. The building that is, call it, I guess, east along Bragg Street, that building actually sits well above Bragg at that location. So no variance is needed for that. Yep, that's correct, the one being identified there. The next building called east of that is 2 feet below Sawyer Street. So again, a 4 foot different than what the city would require. Next building over there at Sawyer and McMacken, that building sits about a half foot above Sawyer Street, but still less than the city requires. And then the building immediately west of that along McMacken, building number 2 on your site plan is 6.5 feet below McMacken, so 8.5 foot difference than what the city would require. So just going to the findings of unnecessary hardship. Again, it's impractical to develop this site and extend Sawyer Road as required by the code, given the significant grade change along the existing streets that we had to tie into for that extension of Sawyer. We analyzed what it would take to comply in this case. And in order to do that, a significant amount of fill dirt would have to be imported to the site to bring the site up, looking at about 80,000 to 100,000 cubic yards of dirt. That's in the range of about $500,000. Again, so the topography is creating this that's unique to the property, not by the action of the owner. And then on the last finding, that consistent with the spirit, purpose, and intent of the ordinance, there is no intent statement relative to this regulation. I will note, just from a stormwater standpoint, that we are complying and installing stormwater infrastructure throughout the site away from the buildings. And again, the development of 200 new modern amenity affordable housing units, serving those earning 40% to 70% AMI in a quickly gentrifying area. And as Mr. Hodge noted, the board has approved many of these requests. There have been a number of them associated with affordable housing projects dealing with topography issues like case A6518 and A10219, both of which were unanimously approved by the city. So that is all for our presentation. If you have any additional questions or more questions about the accessibility requirements of the LIHTC funding or any other questions, we have our engineers and architect on the line in case you have any questions. So thank you.
Okay, thank you, Mr. Birch. I'm not sure, I guess it's a question or maybe an observation. First, it's a very complicated site topography-wise, so a lot of moving parts here to work with. I have a concern, and I don't think it's going to be misrepresented here, but I just need to state it, that as we have increasingly experienced heavy rain events and the potential that represents, and it's sad but true with so often with affordable housing, it's not always in the best sites. Therefore, sometimes it's the sites that are more prone to flooding or weather-related events. I do not know that that's the case here, particularly given this topography. But I simply, I trust that as you and your team have looked at this, heavy consideration has been given, certainly with your stormwater, to managing the water on site so that 5 years from now, this does not become a problem site because we've compromised this figure. So just any response to that, maybe your engineers would wish to speak to that?
Yes, I know this is something that they've certainly looked at, and I would just defer to either Jim or Tim with Timmons if they want to just kind of quickly address Chairman Swink's comment.
Yep. This is Tim Grissinger with Timmons Group. We have taken in consideration the rainfall data in this area. The stormwater detention that we're proposing will include the 100-year storm event. And like you said, Mr. Swink, the topography of the site, looking at this plan to the down to the bottom of it is a City of Raleigh owned park area. There's a large creek down there. I can't recall the name of the street off the top of my head. So the site does flow down there pretty quickly. We will discharge at that point. But yes, there's been a lot of consideration taken to stormwater and what we could produce or what is, pre and post conditions of the site. So.
Okay. All right. Thank you, Mr. Grissinger. Board member questions.
Mr. Swink, this is Marvin. So, Mr. Birch, to your comment about the 80 to 100,000 cubic yards of field dirt to be brought in and at the cost of $500,000, would this help alleviate faced with in terms of Mr. Swink's comment about improving the site so that down the road we wouldn't have any major issues as it relates to the rain fall that we're currently experiencing? So by bringing in the dirt and not have to ask for so many variances here, Would that help and also alleviate some of the ADA requirements you're asking for relief for?
Relief from any ADA requirements.
Okay.
We're actually asking for a variance so that we can comply with ADA.
Okay.
Without a variance, we could not comply with ADA as required by the LIHTC funding sources. And 2 points about the amount of fill dirt. Number one, as with most affordable housing projects, funding is extremely limited. As I mentioned, this is being funded through the low-income housing tax credit program. I believe the City of Raleigh and Wake County are also funding partners. And so the cost would really be prohibitive in this case to achieve the number of units that they need to achieve to serve this area. But I think as Tim mentioned, they are obviously allocating some of that cost to a very higher level, detaining to a much higher level storm event, the 100-year storm, than is required by the city, where it's just the 2 and the 10-year storm. And there are, again, a significant amount of stormwater infrastructure along the sides of these buildings to collect that stormwater, direct it into the underground stormwater facility, and then release it into Chavis Branch, again, which is kind of bottom of the page as you're looking at it now.
Okay. Thank you, sir.
Yep.
Okay, thank you. Any other questions from the board? Okay, Mr. Hodge, do you have any questions for the applicant based on what you've heard?
I do not.
Okay, thank you. Anyone else here wishing to speak in support of this request? Anyone wishing to speak in opposition to this request? Okay, Mr. Birch, any last words, any additional thoughts?
No, sir. We appreciate your time.
Absolutely. Likewise, Mr. Hodge.
Nothing else. Thank you.
Board members, any last questions? Hearing none, we'll close the evidentiary hearing and let's move to the board for deliberations. And a motion?
It's Mr. Mile. I'll make a motion to approve.
Thank you, Mr. Mile. Do we have a second? I'll offer the second. Any further discussion? Mr. Puccini?
Thank you. Mr. Mile?
Approve.
Thank you. Chairman Swink?
Approve.
Thank you. Somebody's banging around out there. Can barely hear some folks. Thank you. All righty. Mr. Kuntz?
Approve.
Thank you. Ms. Rudisil?
Approve.
Thank you. Mr. Sutton?
Approved.
Thank you.
Okay, thank you very much. Thank you, Mr. Birch. Let's move along to our item 3 today, approval of the minutes. I apologize. I believe I received the minutes. I can't find them. So
They should have been uploaded in board docs by last Thursday at 5 p.m., which is the deadline to upload all final materials. Are they not up there?
they may be. I apologize.
I reviewed them.
They're
there.
Very good. Okay, that's my mistake then. But they're available. I'll entertain a motion for motion to approve. Is there a
By
second?
whom?
John Coons.
Yes.
Thank you.
Is there a second?
Second.
Okay.
All righty. I roll call. Mr. Kuntz?
Approve.
Mr. Mile?
Approve.
Chairman Swink?
Approve.
Ms. Rudisil?
Approve.
Mr. Sutton?
Approved.
That makes 5.
Okay, great. Let's go to Ms. Hill for our attorney's report.
Okay, and I'll be really quick. I know you guys have been a long meeting today. We have a really quick housekeeping matter. Under your rules of procedure, you are supposed to elect officers at the first meeting in July of every year. And as you know, because of this pandemic, your April meeting was canceled and you're about a month behind. So that's why we're about a month behind in getting to this as well. So your rules of procedure call for a chairperson, vice chairperson, and secretary. All 3 positions, your rules say that the term is for 1 year or until a successor is appointed or elected. You're eligible for reelection. There's no term limits. The majority of the board membership is required to elect an officer. So since there are 8 board members total, then it would need 5 yes votes to elect an officer. And officers have to come from your regular membership. So your current chair is Mr. Swink, vice chair is Mr. Coots, and secretary is Mr. Mile. So you'll need 2 nominations and a vote on each one of those positions.
Can non-voting members nominate?
Yeah.
Okay.
Yeah, and you can vote as well. It's just that you have to select a regular member for the position.
Okay, let's start with the chairperson.
I nominate Rodney Swink.
I second it.
Okay. Thank you, Mr. Coons, and thank you, second. Anyone else? Then let us vote. Do we do this by roll call?
I would, just to be double safe.
Okay. Mr. Puccini, we're going to vote by roll for the chair.
Okay. Thank you. All right, then. I will start with, I will not call you, Mr. Swink, since you are the nominee.
Okay.
You will not be participating.
Thank you.
All righty. Mr. Coons?
Approve, I guess, yeah.
That's good. Okay, Mr. Butler?
Affirm.
Thank you. Mr. Mile?
Approve. Affirm.
Thank you. Mr. Kenny?
Affirm.
Mr. Sutton?
Affirm.
Ms. Rudisill? 1, 2, 3, 4, 5, 6. That makes 7. That makes 6. Thank you.
Okay, thank you. Vice chairman position, I'll nominate John Kuntz again. Anyone else with nominations? Then we'll close that and we'll have our votes for Mr. Kuntz for vice chair.
With you, Chairman Swink.
I approve.
Thank you. Mr. Mile?
Affirm.
Thank you. Ms. Rudisill?
Approve.
Thank you. Ms. Sutton?
Affirm.
Thank you. Mr. Butler?
Affirm.
Thank you. Mr. Kenny?
Affirm.
Thank you. That makes 6. Thank you.
Okey doke. And thank you very much. Our secretary, currently served by Mr. Mile. Do we have a nomination for secretary?
I'll nominate Mr. Mile.
Thank you. Is there another nomination? Okay. Thank you, Mr. Butler. Let's move to a vote.
All righty. All right, Mr. Butler?
Affirm.
Chairman Swink?
Affirm.
Mr. Kuntz?
Affirm.
Ms. Rudisill? Thank you. Mr. Sutton?
Affirm.
Mr. Kenny?
Affirm.
Thank you. That makes 6.
Okay, thank you all. That's too easy.
Thank you for your leadership, guys, for taking on this responsibility too.
Well, it's a good group to work with.
We're just getting in the groove now. I didn't want to disrupt anything.
Catherine, anything else from you today?
Nope, that should do it for me.
Okay, as for me, again, thanks for the discussion today. Good questions. You raised some good issues. Normal, but I think we covered good ground today. So I'm happy with the way things are going. Does anybody else have any business?
Just an FYI, when I do the minutes, I'm going to have, of course, Catherine's report as you're advising you what the procedure is, separated from the actual elections. The election itself will have its own heading in the minutes.
Okay.
Just keep the 2 of them separate.
Okay.
One question about so if there's a chance this fall I'll be out on a Monday. If that's the case, I'll obviously just let people know well in advance, and then my alternate steps in, correct?
That is correct.
Okay.
And I would just say too, Mr. Swink, I would second what you said earlier about the good questions today. And last meeting as well. I don't know if we mentioned it last meeting, but you guys are asking good questions of the applicants related to the standards and to have them put on their case. So keep it up. So, good questions.
Yeah, I think so. Okay, well, if there's no other business before us, then I think we stand adjourned until next month. Everybody stay safe.
Thank you. Thanks, Rodney.
Same here. You guys be good.
safe.
Not all.
Good night.